I apologize on behalf of I don't think the minutes from last week are ready. But I do, as we have done in the past, once they're ready, we'll go through them and give an extended time for any corrections. We were in the matrix the last time, and I believe we had discussed some items that members wanted some further information on. We had discussed the consumer price index and its composition and when it would change. We had some issues that were pending on the regulations and the PBMA. We had some issues on fit and proper, and then we were on the mandate with respect to where we are in the legislation itself. I propose to hand out the document I mentioned that I would on the CPI composition, so members can be informed, and then we can go to deal with other substantive matters. I'm going to ask if somebody can just hand these out. So I can give the orderly. Okay. So the CPI, Member Golding had asked about it, and I'll just read from this. The consumer price index and measures changes in the general level of prices. Thank you. Of consumer goods and services
Chair.
Purchased by private households.
Chair, what are you reading from there?
A document from Statin that I asked them to prepare that I could share here that speaks to the basket when it was last updated, how the timetable for this update and when that update will be implemented. It may not be necessary to read it into any record, but just for the background information. So the background is that the current weights that we have are pretty old. They're from 2005. That we are updating the basket now. In advanced economies, baskets are updated every 5 years. In developing economies around the world, it's usually every 10 years. The data collection goes into the household expenditure survey that is conducted by, I believe it's the PIOJ. And there were 12 monthly household expenditure surveys that ended in March 2018 that would assess how Jamaicans spend their money. And that survey feeds into the basket. The data analysis is being done now, and the new items are being incorporated for the full year 2019, and the new basket will be first used in the May 2020 CPI measurement. And we have technical assistance from CARTAC in Barbados and from ECLAC to ensure that the methods being used adhere to international standards.
So, Chair, may I ask if this is going to be the new format going forward using these parameters?
Yes, so the basket will be updated and will include the new weights. I mean, it's 400 items, and as I said last week, it's unlikely that you're going to get substantial the changes are incremental. They tend to be. And going forward, it is going to be important for us to see if we can keep to that 10-year schedule.
We're now 14 to 15 years behind.
Correct.
Well, as I said, Minister, based on the fact that inflation targeting is now going to be central to what the central bank does and be primarily what they're about, I think the inflation target, and the data that gives you, that measures inflation needs to be sound. So I would like us to consider moving to the best practice, given that we're moving towards a new regime of inflation targeting, which will make the inflation rate all the more critical. So I think, I think that would be good if we could set that as a goal or possibly, commit to it,
No, I support that. There's no reason why we shouldn't be at what the advanced economies have, which is to update it every 5 years. It just comes down to budgetary allocation at the end of the day. Once we have it as a priority, it will get done. We have the people to do it. They just need to be provided with a budget to allow them to do it. So I think if we're in agreement on that, I think it will happen.
Is it very expensive to do?
Well, it is expensive in the sense that it takes resources that you would normally use for your GDP and your other measurements away. It's a household expenditure survey that you have to do every month for 12 months to make sure you're picking up any changes and trends. So it does take resources that you would normally use elsewhere. But in the grand scheme of things, it is something that we can afford. And it's something that we should, commit to.
Great.
Chairman, could I just add perhaps to that it's, just to be clear, it's not just for the CPI. It has this value. The Household Expenditure Survey is very valuable for many other purposes of government in terms of how it, where are the problems, what are income levels. So it's for us, for the CPI, but that's not the raison d'etre for the Household Expenditure Survey. It has a bigger value.
I just welcome Senator Brown, Senator Johnson-Smith, Member Campbell to the meeting, and Senator Gale. Okay, so just put water for me. Let's move into some of the items that we had discussed last time. I believe the central bank we were discussing the regulations and the fact that we want regulations to apply and regulations, public body regulations to apply to the central bank. And I think Member Golden had put forward the ones that he would want to see included, and we had asked the BOJ to cross-check and make sure that those all are included, notwithstanding the argument that we could still have the PBMA apply. But you want to take it from here?
Thank you, Chair. We did look back at all of the points that Member Golden had raised that he thought should be included for the Bank of Jamaica notwithstanding, and all are included in the proposed regulations that regulations that we're proposing. We have a document which outlines this, and also other points which we think would clearly indicate that there are conflicts and inconsistencies in the PBMA as it regards Bank of Jamaica. So that document is available, and with your permission, Chair.
Please circulate.
Yes.
Yeah.
Okay. Would you?
Well, given the nature of it, you think it's something that we can discuss now, or people would probably need to digest it?
You want to? We could go through it at a high level. It's up to you, Minister. When you look at it. Yeah.
How long is it?
Not 17 pages. It's
in the spirit of
8 pages.
Minister, Chairman, in the spirit of the care of the comment, the detailed necessary, this sets out a lot of detail. So it may be helpful to go through it themselves and then satisfy themselves. We've tried to be comprehensive.
So you'll notice Table A, members, which reflects the comparison in terms of the points that were raised by Member Golding, and Table B relates to those points which the Bank of Jamaica indicates are inapplicable or are inconsistent with our statute.
The Table B deals with the things in the PBMA that are
in the PBMA. Okay, yes.
Yeah. So we were told last week that the draft regulations are quite advanced, or did I not hear that correctly?
Yes, they are.
I'd like to see that, yeah, so they could be enacted as part of this bill. Yeah.
The idea is that the bank would have a role in the recommending the regulations to the minister, and then the minister would bring them. So that there's a mechanism we are proposing here that would help to be sure that the regulation
that could apply to amendments or additional regulations, but the ones that you're going to start with, could we not have them recommended as it were now, and enacted as part of the process?
I think that's a decision to make,
Yeah.
but since the act is not set yet until you complete this process, there may be other amendments, debate, etc. So we have.
I would not be comfortable
We have
eliminating the application of the PBM in its entirety to the BOJ without the regulations being in place when it is passed, especially since it's quite possible to do it.
So we have we have what we think. I'm just making the point that
I think it's a reasonable compromise, and I think it is definitely within the capacity of the government to have the proposed regulations available, given where we are.
Chairman, I thought last week there was a proposal that it could actually go in as schedule, not as regs, but as a part of the act. So it could go into a schedule of the act, and you can always put in
executives who sit on the board, namely the governor, the senior deputy governor, and the deputy governor who will sit as a member of the board being responsible to ensure that the other officers who fall within the management are the appropriate due diligence applies. So the recommendation that we would like to put forward for the consideration is considered was for, as we know, in the current bill, the board appointed members, the appointed members of the board would be, the determination would be by the minister acting on the advice of the governor. And in relation to the senior deputy governor and the deputy governor who is appointed to the board, the suggestion also is that this also be the minister acting on the advice of the governor. As one will recall, the senior deputy governor and that deputy governor, in terms of that appointment, is by the governor general in council on the recommendation of the board, and so we thought it would be appropriate for the minister acting on the advice of the governor to adjudicate on that in the same way that he would for the appointed members. In relation to the governor, though, we thought that solution to that would be for the minister acting on the advice of the appointed board to determine the status, fitness, and propriety status of the governor. And as one will recall, that is the appointed members per section 6.2d of the Act. So for everyone, it would be minister on the advice of governor, save and except for the governor, it would be on the advice of the appointed members of the board, of course, none of whom report to the governor.
Right, okay, so
Is that recommendation going to be circulated, or is it?
we could have it circulated. I'd probably make it better to discuss it than if it's in a written form. Okay, fair enough. Okay, then that brings us then to
One issue, which was sort of gently floated last week, which was accepting perhaps that requiring the fit and proper test to be passed by a deeper cadre of officers in the bank may be difficult, but there was what was discussed was possibly having some principle embodied in the Act in terms of in hiring staff, seeking to ensure that the staff are persons who meet high standards of propriety and probity, or some such statement of principle that would be guiding which we should, ought, of course, in the normal course of things, to guide the deliberations of whichever mechanism deals with hiring new staff in the bank, but giving it some statutory weight rather than it just be an obvious thing that should apply. That was discussed as well. Yeah.
Chairman, am I to understand from Member Golding that what he would be proposing, these things are normally entrenched in a recruitment policy? Are you suggesting that it should be now a fixture in the statute itself for that requirement to be applied?
Yeah, exactly. There's a statement of principle.
Just a statement of principle.
Yeah,
okay.
Yeah, which would be consistent with whatever the recruitment policy. What the recruitment policy should be consistent with it, really. But yeah,
Okay.
yeah.
Okay.
All right, Governor, let's see if we can incorporate that into what is written, and then we can discuss it. Yeah?
And in fact, we do have bylaws for the bank, as you may know, and so we'll look to see whether it would be more appropriately done there, and we'll put that forward in the document as well.
And then...
Sorry, Chair, those bylaws are subsidiary legislation made under the Bank of Jamaica Act?
From 1960, yes. And those are probably among the documents that will need to be reviewed along as part of this process, but they're coming from 1960.
It's one set of bylaws?
Yes,
yeah.
Yes.
And while we spoke about that, I believe it was a request last week that we the Principal Act be presented so that whilst we are going through, we can cross-reference to what the Principal Act indicates as opposed to what the bill is proposing.
That is correct. I don't believe that you have it, no?
Yeah, it exists. The Act exists in different amendments. So we would want to be guided, and we can certainly help by putting together what we have, but I think the clerk and the parliamentary folks would have to have the last word.
So whose responsibility will it be? When it's shared responsibility, it tends to fall through the cracks.
No, we will help in whatever way. We will do whatever. We can assemble something, but we're aware that there's the people who are responsible for the laws.
But can you take on responsibility then and liaise with them?
Yes. Yes, we will be happy to. And we will
apologies. Hope to have it for next week.
Yeah.
Okay.
There are 3 or 4 things. So, for example, a lot of amendments are in the schedule to the...
Sorry, Chair. Could you just ask the Governor if he could share Mrs. Chinqui Aiken mic, because I'm not hearing him very clearly.
Oh, sorry. I'm not speaking closely enough. I beg your pardon. Yes, Minister, we will take that on. And I was just explaining that, for example, large pieces of amendments to the Act were done in a schedule to the BSA. So we will provide those extracts of those statutes.
You don't have a consolidated?
We do not, no.
You haven't put one together informally?
No.
Okay.
Well, no, I shouldn't say no, but it's not fit for circulation.
Yeah. I'm being updated by, they were trying to put it together, but they were defeated by the number of places that it actually exists. Exists in all these places.
Yeah.
The Ministry of Justice should prepare the laws of Jamaica, right?
We were
combined every single year
that.
and distributed it to all members of both houses. That's where we need to get to, right? Yeah.
There's a process called law revision, where when we pass laws which amend other laws, the law revision process involves the laws being introduced into the laws of Jamaica into one document. So they update the principal acts by reference to amendments, but they've been a bit behind. It's a small unit. Well, yeah, so I'm interested is when we're getting the 20, 15, and 16 pages. That's what I'm interested in, because if that had been done, we would have a consolidated BOJ Act with those amendments in it, you see.
Okay, that brings us to the matter in the clause by clause. We were in clause 5.2, and matter came up on the lend of last resort. You want to just respond to that, Governor?
Thank you, Chairman. We took a look at it for the discussions, and what we noticed, we take note that first, that the functions of lender of the power to make these to make this kind of credit available is in the Act under Section 23F. Section 34M is also in the Act. I think we spoke about this last week, so I don't want to dwell on it, but the 34M is also in the Act, and that was put in under the Financial Stability Amendments in 2015. And those were intended to address the question of, is this broad enough to encompass the anybody who might need it? So that's where our lender of last resort powers are located. And the question raised was to put in the functions of the bank some reference to this lender of last resort function. And we think that this would not be advisable or desirable. One of the main reasons is that the lender of last resort function embodies considerable moral hazard issues. So it's vital that the central bank has the power to exercise it, but it's not something that you want to now create, in a sense, some sense that this is actually either obliged or guaranteed, or that somebody ought to provide it in any given case. It's a delicate question. Many countries grapple with this, especially after the global financial crisis. They re-looked at the same issue. We have not found in our survey so far countries that have put a lender of last resort function explicitly spelled it out in their functions section or their mandate sections. And we think that that would not be desirable. At the same time, the 2015 amendments created the financial stability objective. I'm using the term loosely, I don't have it in front of me, for the bank. It specifically inserted that as part of the bank's mandate, and it's something we're preserving. So that, and it's under that rubric that the lender of last resort function rests. So the powers are there. The issue is covered in this language. It does not, in our view, generate any moral hazard issues by the statutory language, and therefore doesn't require, or we would advise against an amendment that would try to spell that out in the law. Generally speaking, in looking at something like this, we would want to have regard to experience and whether we have found it to be an obstacle, whether here in Jamaica or elsewhere, so we could say, look, there's an issue here and we need to fix it. This is not one of those cases as well. So we were asked to take a look and look at other experiences. That's what we have so far. So we would recommend that we would suggest, actually, I should say, that there not be a function put for lender of last resort, and that we accept that we're applying these activities under the financial stability objective or function of the bank.
Yeah, I mean, the issue of moral hazard is we're moving towards the direction of setting up a special resolution regime to deal with issues of bank failure that, institutions can go through that part of the life cycle without there being contagion. So the prudential regulations are actually moving in a slightly, and I think the governor said it best.
Could I add, sorry, Chairman, please? I should indicate that also the work on these issues of how do you deal with resolution of financial institutions that are in distress, the government, the Bank of Jamaica is carrying out work to develop for the government to present legislation that will upgrade the country's resolution framework for these sorts of entities, systemically important entities, all entities, in fact, that will address how you resolve them when they're in difficulty. And the broad goal of that, which is to come here for this discussion, debate, approval, and so forth. So there are many, many issues in there, but that is a place where this kind of question, or lender of last resort, will come into that picture in some cases that are borderline. You have to be solvent to receive lender of last resort work, but what if you're borderline solvent? What if you're in distress? What if you actually need to be wound up in some way in an orderly fashion? And how is that done in a way that is done early enough to protect the depositors, obviously, and other stakeholders, but also the fiscal, the public purse? So there's a lot in that, Chair, if I may say, and I would say that to the members who are looking at this question, there's an opportunity for a much fuller consideration of the resolution questions embodied in that proposed statute, which should be imminent this year. It's under a lot of work is being done on it.
Mr. Chair, one question I have on that is: are we approaching that just as an exercise for deposit-taking institutions, or will the resolution, the new resolution regime, apply more broadly to all entities that are receiving funding for clients? That's that's especially. I mean, there's always been this kind of ideological approach to separation and that of how we deal with the institutions between deposit takers and others. Sometimes I think we overdo that based on realities on the ground. Or obviously, the distinction between the two is important. But if you're talking about resolving institutions that are in distress or otherwise, it would be appropriate to have an updated regime applicable to all entities in the sector which contribute towards financial system instability when they go wrong. And there are some large players out there that are not deposit-taking institutions. So that's a question I have. I don't know the answer to that. But I have another issue on the point we were discussing about functions and so on. So maybe that's a quick answer.
Yeah, short answer. The proposed legislation is comprehensive in how it addresses all of these segments. Yeah, they're not in the same way, but it addresses
but it will
yes.
be a kind of pan sector.
It deals with the issues of insolvency of the financial sector
as a whole, essentially.
All of these licensed regulated entities.
Regulated entities.
Because remember, the BOJ now has responsibility for financial system stability, not just stability of the deposit taking, but for everybody.
Yeah. Yes.
So the special resolution regime is very, 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 very dense and very complex.
But the Financial Services Act has provisions around taking action in certain circumstances in their schedules, which are really limited to entities that they regulate.
Right.
So I'm assuming those will be updated or
correct.
replaced.
And not only that, the Bankruptcy Act has to be updated as well, because today the Bankruptcy Act has jurisdiction or would have jurisdiction. The idea is to deal with insolvency or distress for financial institutions with its own specific resolution regime, extracting those sections from the Bankruptcy Act that we think should apply, extracting from the FSC what we think should apply, and putting in a comprehensive set of. It's very, very complicated.
It will be.
Very, very, very complex. Yeah.
Well, the Insolvency Act itself is very complex.
Exactly.
So when you're talking about cherry picking items from it and not others, that's. I hope we're following an international model.
We're following, yes, we're following an international model. But when it gets here, it will generate a lot of discussion, I'm sure.
The other point I
had a question on this point, if you're moving on to the other one. Mr. Chairman, I've listened carefully to the governor, but I can't say I'm persuaded. There may be some legislation coming down the road, but as we know, sometimes these take quite a long gestation period. And if we're dealing with something now, I don't see any harm in addressing an issue in the current bill that we're looking at. The financial system stability is an object of the bank. Financial system instability is typically triggered by a liquidity crisis. It may eventually develop into an insolvency, but a liquidity issue can then morph into an insolvency issue. The only player that can provide liquidity in substantial quantities at the time of such a threat is the central bank. There will be no other player. And since we have recognized that an object is financial system stability, the governor has told us that the powers are also there. I cannot see why we refuse to connect the dots by making one of the functions to provide liquidity, not be a lender of last resort. We don't, I mean, because that is a term of art that's typically used with reference to deposit-taking institutions or banks. But to perhaps to provide liquidity in pursuit of financial system stability. I can't see what harm that does by inserting it as a function of the bank to connect the dots between the objects and the powers which are in other sections. And he says that there's been no issue around this, and I disagree with him, because maybe it's the perspective. When you sit as a regulator and institutions going through this liquidity crisis, maybe teetering on the edge, it doesn't perhaps prevent him from sleeping at night. But I can tell you, in the days when we were there, I mean, it was, we've had some close calls. And I'm not talking about one or two institutions, I'm talking systemic calls. 2003, again in 2008, I think, Member Golding said at an earlier meeting. So I really think it would be useful to make that link and not leave it to the discretion of the particular governor that is there. And, these are some of the positions that when we create them and we clothe them with independence. So in these times, their discretion is going to be largely determining what happens. So we have to anticipate these types of things and make provision in law so that it puts more than just a discretionary authority, but it puts an obligation on the governor and on the bank to respond.
Sorry, that was the second point I was going to, was addressing that issue, so if I could just add it. On the moral hazard point, I don't think we can pretend that the powers don't exist, because they're in the Act already. And indeed, financial system stability is being set out as an object of the central bank, admittedly subordinate to price stability maintenance, but nevertheless expressly an object. So the moral hazard argument doesn't really hold much water in these circumstances, because those powers are there already. I think it's more a coherence issue from my standpoint, where I would just like to ensure that in addressing whether or not to exercise those powers, a governor is forced to bear in mind that one of the functions of the bank is to exercise those powers in furtherance of the object of financial system stability. It's really a legal coherence for me that I'd like to see in the structure that we're designing. Yeah.
The challenge is that as you acknowledge, it's already there in the Act, and the governor mentioned it's there in two places in the Act. Putting it as a function, elevates it to a level of creating an expectation which can be very damaging and costly and doesn't accord with best practice. I mean, like you see, all the suggestions have been taken on and have been reflected on in consultations with technical advisors and so forth, and there's no precedent for the elevation of that issue to a function of the bank. At the end of the day, the bank is a call on us, the public, at the end of the day. And the issue we all want the central bank to focus on is financial system stability. We cannot, eliminating various forms of risk, whether it be credit risk or liquidity risk or gap risk or other forms of risk, is not what the legislation, is there for. There has to be some element of risk if there is going to be reward, and so we have not seen anywhere where that function is elevated to the level that's being proposed, and in fact, it is seen as highly dangerous from the,
Could you point us to those sources?
From a technical perspective. Huh?
Could you point us to the sources, the highlight?
No, I'm saying that
I'd like myself to go to the source.
No,
studies.
we've said we don't have a precedent. We haven't seen a precedent on that, and I want to put it.
No, you said that it's found to be highly dangerous. I myself, if you don't mind, would like to see these studies where it is found to be highly dangerous.
I didn't say a study. I said we would have consulted with technical advisors.
But could I see the technical advice or hear the technical advice directly?
I mean, I don't. The legislative committee is not set up for that. I mean, if you think that there's a misrepresentation, I mean, it's not set up for that.
So this is sort of like the state of emergency where we're told that the commissioner, the security forces recommended, but we're not allowed to weigh the arguments ourselves to determine if it's cogent and persuasive. With respect, Chairman, I think we have enough experience in the industries. One thing to be theoretical or to see it only from the regulator's perspective, but it's a completely different perspective from having been a player in the industry. And I think it is a useful perspective that we're bringing to the table. And I don't think we should be, our opinion should be just discarded because some expert somewhere who is only living in a theoretical or regulatory environment and doesn't have to bear the consequences of what happens when you have a liquidity crisis precipitated by central bank incompetence that then threatens the solvency of or the stability of the system. I would like, for example, for the governor to tell us what percentage of the system, of the financial system, is represented by deposit-taking institutions versus the other range of institutions in the system, and that might help us to determine how important this function is.
Chairman, in listening to the response from Member Bunting to my remarks, I do think it's important to clarify or re-emphasize that what the bank was asked to look at, or what we understood that we were to look at, was the lender of last resort function. This is where entities will fail and the bank will bail them out through liquidity. I believe in the explanation or the response, what I was hearing was not the lender of last resort. I think you qualified that, which does exist for non-banks, just to be very clear, and that's the issue that we were examining, and that's what I presented on. But I think you've broadened it to the fact that there are other financial entities that may not be at the lender of last resort, so it's not a bailout, but they would wish to have access to central bank liquidity. And I think that's the point I'm hearing, which is not what I was addressing. Okay? Yeah, now you're talking, I think you're outside of the realm of the financial stability mandate, but in the realm of going concern businesses, regular running. Things are stressful. I think the remark was made that the central bank created the liquidity crunch and therefore they should have been providing the liquidity to prevent the institutions from failing. I can't re-examine that past, not here, but you can obviously see that there could be conflicts in the monetary policy actions of the institution, and the judgment of whether they were right or wrong is a judgment that is important to have accountability to be able to police it. But that's the past. Looking forward, if we're dealing, Chair, with going concern situations, it's access to the central bank liquidity by non-deposit takers. Okay, that's actually always a current issue presented by securities dealers in particular, basically securities dealers who would like to have that access. During the last few years, a change has been made to provide access on an emergency basis, and hence Section 34M, which is meant to be where they face these situations. The central bank established requirements for institutions if they, so that in accessing that, we could do it in a proper way and give it to institutions that, have recovery plans, et cetera, et cetera. What we found is that, and it's probably what we would expect, that institutions have not been keen to access or to even go through the requirements to meet from the central bank this sort of emergency access. I think there may be issues that could be examined about stigma and perception, et cetera, et cetera. But just to be clear to the members of the committee, in looking at how to manage a system on a more going concern basis, That door was opened, and there is a mechanism where institutions that are not banks provide recovery plans to the Bank of Jamaica so that they would be able to access on an emergency basis this funding. The changes, the implementation or the putting in place of Section 34M 2015 was actually specifically designed so that there would be a mandate and a means for the bank to do it. Now, having said that,
it was done before in practice a couple of times, I'm aware of.
I would defer to you on that, but in practice, but in the so we were debating, I think, or discussing rather, the moral hazard issue around lender of last resort function. But I think if the discussion is about going concern access, so where you don't have a crisis, you're not going under the stigma of emergency access, you're not failing, but you just need liquidity, then I think we should be discussing the design of the financial system, the rules under it. So banks, DTIs provide information, exist under a regulatory regime that is designed to make them the source where liquidity comes automatically once they're solvent, once they have assets. Securities dealers are under a different regulatory regime. It's within the power of the government and the legislation to change that. I would submit that this function here is not the place to address that. We have to look at the regulatory regimes that we have.
But Chairman, the 34M, is that the correct reference, can only be exercised in a vires way, in an intra-vires way, in furtherance of the object of the central bank as laid out in the statute. If it's used for any other purpose, it would be an improper use of those powers. And the object is financial system stability. So we're not talking about using it because somebody might make a loss, or using it because somebody has failed to account for a particular risk, and it would help them to avoid some hit to their P&L. That's not what we're talking about. We're talking about a situation in which typically institutions or systemically important institutions need access to liquidity and can't get anywhere else, and that's what 34M is there for. And it's enabled, it's only possible because the object of financial system stability is embraced by the statute. So all I was talking about was ensuring that the functions were consistent with that conceptual framework, from objects to powers. That's all that is. And for my mind, the function could be as bland as something like exercising the powers in the Act in furtherance of the object set out in subsection 1. It's almost self-explanatory or self-evident that should be the case, without mentioning lending of last resort, even mentioning liquidity. But the powers are there already in the statute. The objects are going to be there as well. And it's just to show that the functions are consistent with that. That, for me, it was a legal coherence point, because when the amendments were made, including 34M, they were very much in mind or mindful of the need for the central bank to be able to play that role, especially in a market like ours. Yeah.
Sorry, Chair, could member repeat that formulation you're putting forward? Sorry.
Yeah, I mean, I'm not attempting to draft anything, but I was just saying the functions of the bank shall include the following, and it would be the exercise of the power set out in this Act in furtherance of the object set out in subsection 1. Something as straightforward as that.
Okay, allow us to consider that. Yeah.
So, sorry, last point. You had talked about, you had a formulation which I'm looking forward to. Yeah.
It's a good thing I never mentioned it last week. You remember you said to me, no, check first? No. So in...
I'm sorry, Chair. Could I just ask a question? So would 5.3 cover...
I'm going to suggest that we just reflect on it. I wanted to move to the H item. That's what you had asked a while ago, right? So to keep it as an inflation targeting sort of regime, where an inflation targeting regime in our case, where we are keeping inflation setting in the government, right? Which in other inflation targeting regimes, the central bank comes up with the inflation target, and therefore they're responsible for growth, employment, etc. By the government setting inflation rate, the government is making those trade-offs of how much growth and how much employment they're trying to target. But in recognition of the thing that you raised, the proposal was, I'm going to ask the governor, so this is what I had suggested as a compromise. You want to just read it, Governor, please?
Thank you, Chair. It would be to put an H on the list, pursuing the above functions in a manner that recognizes the government's growth and employment objectives.
Well, that's definitely an improvement.
Yes, so it's an improvement, yes. And it's the same thing like what you suggested a while ago of making it logically consistent, right? So it's saying that what you're doing can't ignore the objectives, but it's implicitly recognizing that at the end of the day, the government is responsible for those. We have not yet turned those over to the central bank. Maybe in the future, when we are, more 10 years from now, 20 years from now, whatever, based on the performance of the central bank, we'll have the confidence to do so, but not just yet.
Could the governor just repeat?
Yes.
Reference again, please.
An H, pursuing the above functions in a manner that recognizes the government's growth and employment objectives. If I may, Chair, there's a little wrinkle, so that's the substance, but I think as you'll see, we have to do a little work on putting it as if it is a function in the list, because it's referring to it. So that with the draftsman, we can just tidy that up. But yeah, okay. But it would be there in subsection 2, referring to those functions.
And Chairman, in relation to subsection 3 and Mrs. Chinkwi-Aiken's point, really, subsection 3 is dealing with powers, and the powers that the bank has are essentially set out in the Act, it being a creature of statute. And this seems to be a kind of attempt at a catch-all to kind of say, even if we don't have specific powers in the Act, we can claim these powers under 3, which I'm not sure that really works, actually, on reflection. But in any event, I wasn't focusing so much on the powers as the function set out in 2. So I accept where I think you were going, which was that that's very much what's covered in 3 already, but it was ready to cover them in relation to the functions provision, but in similar terms, essentially, yeah.
Chairman, if I may, Chairman.
Please go ahead.
Thank you. I just wanted to make it clear that even though the committee will give its instructions and directions, number one, perhaps you'd still want to leave it to the drafter to see how those words fit in. So for instance, the words that were being said, it's not really a catch-all to the functions. So I don't know if it's really appropriately listed in the list of functions. It could go in one of the other subsections that go right after that list. Those words could be then captured either in 4 or in its own subsection, just to explain how you then carry out or perform the functions, how you pursue the functions.
Okay. So we're on subsection 3 of... No, we were doing 4. The bank shall carry its functions, right? Can we move on to 5?
Clause 5?
Clause 5. And in clause 5,
Chair, if I could comment. Clause 5A of the bill proposes the amendment to section 6.1 of the Act to revise the board's mandate to include strategy, policies, and general oversight and administration of the affairs of the bank. The section 6 currently does not reference strategy or oversight as functions of the bank. And these new oversight functions that are proposed are important to the new dispensation as they facilitate greater accountability. At present, the statutory committees, the Supervisory Committee and the Financial System Stability Committee do not have any relationship with the board at all. So this proposal broadens the remit of the board to take account of all these statutory committees and help properly oversee the functions assigned to these committees. This would not result in the board being able to second guess or overrule decisions of these committees. What it will do is to allow the board to review the general functioning and activities of these committees and ensure that they're in keeping with their...
Vis-a-vis today, it empowers the board.
Yes.
Vis-a-vis what we have today.
Right. The board does not have broad oversight of some of these important functions at the moment.
Okay.
Mr. Chairman,
if we can move to subsection B. Oh, sorry, ma'am.
We had made the request at the last meeting if we could have got a copy of the bill. I don't know. I apologize for being late.
Before you came in,
sorry.
yeah, before you came in, Senator Gale raised it and we tendered an apology. The bill is, because of all the amendments over the years, is in many parts and pieces. The House of Parliament was trying to put it all together and was sort of overwhelmed by the number of parts and just didn't have a complete thing to send. The BOJ, before you came in, offered to help because they have not in one document, but they have a folder where they have all the pieces, and so they'll do it and circulate it. And I think when you get it, you'll see the difficulty that they had in putting it together.
Okay. Well,
Chairman,
in the absence, could I ask the Deputy Governor just to tell us what the existing clause that this is replacing? Oh, it's here?
This is 6.1.
The left-hand page
is page 4. Yeah, they are at the top. Oh, you have the wrong one. Oh, yes.
So it says, if I may read it, there shall be a board of directors of the bank which, subject to the provisions of this act, shall be responsible for the policy and the general administration of the affairs of the bank.
That's the
so
current
there's no
one.
oversight, and that's the current.
Okay.
So it doesn't have the words oversight, it doesn't have the word strategies.
Page 4 of the left-hand pages.
So the catch-all then is the general oversight. That's in a sense what expands the mandate of the board. Because you said administration is there already and policies.
But not strategy. It's strategies and general oversight.
And general oversight.
Yeah.
And strategy is intended to include the work of the specific statutory committees.
The idea is to preserve, to oversee, to be sure that they are doing what they're supposed to do. Not second-guess decisions, but make sure they're on mandate, everything. So that's the intention. So the board will have oversight of everything that the bank does. And then, Chairman, in the proposed regulations that we were just speaking about, we further elaborate in terms of the board's functions, so that it will cover, speak to things like setting the medium and long-term strategy of the bank, and clarify that it's not going to be dealing with the decisions of the committees.
Mr. Chairman, I recall speaking with a former director of the Bank of Jamaica who was not an executive, and he expressed that the only decisions that came to the board were things like the canteen concession. It was about as important a decision that was made, and I'm sure the governors made sure that they kept it at that level. So what is this now, by providing for this general oversight, somebody who would be a director, not being a governor or deputy, or not being an employee, an executive director, would have more involvement in the general oversight of the operations of the institution?
Yeah, that is the case. And I remember, Bunting, I can I sat on the board of the BOJ, and I can attest to the canteen contracts.
You can confirm
and the supply contracts and so forth. There's a monologue by the governor for the first half an hour, and he takes up the time with the monologue, and then you get to the canteen contracts. This is going to make sure that the monologue can't work anymore, right? Eliminate it.
We call it transparency, but obviously.
Chairman, I very much doubt that this will have that effect.
But Chair, if I could, I think it goes a little further, and I think it's important that we realize that, and I think you'd mentioned it in our previous meeting, and I think it's worth emphasizing that a key change in this whole framework, and we'll see it with the MPC and the FPC. This is where those decisions that are what the bank does, that currently the governor makes, they will be residing in those committees. The governor will chair them, but there will be these other members, including other appointed people, not board members, who will be sitting there making those decisions. And so the board is set above it to oversee their activity, to look at questions like, which I'm sure they will, here's a committee that's not functioning or appears not to be functioning well. Why not? What's going on? Is it getting the resources it needs, or is it deviating from its mandate? So that the board can be answerable. Ultimately, the governor will chair the board, but the board and those appointed members will be able to be answerable for the performance of the bank in its substantive functions. But I just want to clarify that the decision-making, we're splitting it up. So the governor makes these decisions now. We're saying, no, it's going to be a committee, and outsiders are on it. And these are two different committees, and there are a couple of others. And then we want to have somebody, which is the board, that can oversee how it all is working to make sure that you're looking at the totality, looking at the details, including the canteen contract, which is not a trivial matter, I would like to say.
With the yes, and all the matters that Senator Gale brings to the board as well. Don't forget those. But with the general oversight for the affairs of the bank, it then becomes legitimate for a board member to ask a question. For example, I saw that the Monetary Policy Committee put out this thing here. Can I ask, how is this consistent with X, Y, and Z? Right? The questions that you can ask are now much broader, because it says general oversight of the affairs, not some affairs or the administrative affairs. It's all the affairs. Yes.
But Chairman, one concern I have, we've moved from, responsible for the policy and general administration of the affairs of the bank, which is what now exists, the policy and general administration of the affairs of the bank, to strategy, policies, general oversight and administration of the affairs of the bank. And the thinking is that this will have some very significant effect, and it certainly does provide a kind of principled argument for the board to say that they want to have more information or want to have a discussion around important issues. One concern I have is when it talks about the policies of the bank, and we're talking about monetary policy, for example, or we're talking about some other policy, maybe a policy that's supposed to be administered or determined by a committee. If the board has responsibility for those policies, how do you reconcile the statutory mandate of those committees with the board? I think we need to think about whether we need to have some language added in some way that establishes that when it comes to the work of those committees, the board may ask questions, seek information, and want to ensure they're functioning properly, but is not able to or should not be seeking to supersede their work and make their decisions for them.
No, correct. General Counsel, can you say can you speak to whether that conflict?
Okay, so just to say that the regulations which were spoken about earlier, the proposal is, here it is. We'll set out the following: the role and remit of the board, and it includes overseeing the general functions of the statutory committees of the bank, save and except for the decisions made by the said committees in order to ensure that their functions are in keeping with their statutory mandates. And so the regulations which will supplement and
but this can't be achieved by regulations. The reconciliation I'm talking about has to be in the statute itself, because the 6.1 is saying that the board has responsibility for the policies of the bank. And we have committees that are responsible for specific policy implementation and policy formulation. So there needs to be something which says, notwithstanding that, when it comes to the remit of this committee, it is the one that makes those decisions, subject to the general oversight of the board. Yeah.
Given that monetary policy is a subset of policies, is a point that's worthy of consideration. You think the change would be here, or the change would be where we specify the committees?
It may be there, and we think it's a good
the drafting
point,
issue.
But it's a good point because the word policy is being stretched in different ways, and that.
So we leave this as a drafting question. So taking on your point earlier, we're not going to step into your domain, right? But if you take the point on.
The drafter wasn't complaining about it, by the way.
I know, and it's not a drafter. It's a law. Is a deputy. No, it is the. Just the new Solicitor General, right? I wanted to make sure. Right, that's right. And this is your first committee as Solicitor General, is it not? No. Okay. I'm seeking to claim some. All right. Fair enough. It's like quit while you're ahead. Okay. So we'll take that point. Can we move on to B? And B deals with the appointment of the deputy governor who would serve on the board. Can somebody just elaborate on that?
Right. Thank you, Chair. So the proposal here is that the clause 6.2 of C of the Act be amended such that the financial secretary, who is currently an ex officio member of the board, be deleted. The insertion would be the inclusion of a deputy governor appointed to the board by the Governor General in Council. The result of that would be that there would be 3 executive members on the board. The governor, the senior deputy governor, are ex officio members, and the third one would be the deputy governor who is appointed to the board by the Governor General in Council on the recommendation of the board. This third executive would be a deputy governor in order to qualify for appointment to the position of a board member, and his or her appointment is not automatic by virtue of appointment as a DG, unlike the case of the governor or the senior deputy governor. The appointment of the deputy governors to their substantive positions is proposed to be done by the board on the recommendation of the governor. So this proposal is, in summary, is for all appointees to the board other than the ex officio members.
Yeah, read part 2 then. So part 2 is the other 5 directors, right?
Yes.
This is taking out the financial secretary as a member of the board, because I always raise concern about the board itself having to apply to the FS for directions and parameters when the FS is already a part of the board. So this now, I don't have to have that challenge anymore.
No, sir. It's
the question was asked. The governor is appointed currently under the amendment to the Bank of Jamaica Act. Is it by the Governor General in Council acting on anybody's advice, or no, just by the Governor General in Council?
That was
the cabinet.
That was a point. I remember. Yeah. It's. Yeah, we've kept that and keeping that.
And that amendment was made.
That applies to the senior deputy as well. Now, how is the senior deputy currently appointed?
you have to, General Counsel, can you use the mic? Because
That's at page 8, apologies, of the bill. Yes.
The scheme is that the governor is appointed by the Governor General and Council, which is the cabinet, right? The senior deputy governor is appointed by the same mechanism, but acting on the recommendation of the board of the bank.
After consultation with the minister.
Deputy Governor, you skip.
I've gone to 9. I mean, what we're proposing, I'm just trying to understand that.
Yeah, so Governor, Governor General and Council, Senior Deputy Governor on the recommendation of the board.
And how will the other deputy governors be appointed?
And the Deputy Governor by the Governor General and Council on the recommendation of the board. So it doesn't, it's the board in its own, they select that Deputy Governor. They recommend it.
Recommends. And we are defining recommendation later so that...
But is 5B that we were just looking at to do with how the deputy governor is appointed a deputy governor, or how the deputy governor becomes a board member?
How become a board member? Because there may be more than one deputy governor.
I'm just trying to understand how deputy governors are appointed deputy governors.
So
yes, this is separate from appointing to the board.
Sorry. If you look at page 9, it speaks to that the deputy governors in their substantive position being appointed by the board on the recommendation of the governor. So in a substantive position of a deputy governor, that would be the parameter, or that would be the authorizing body. And in relation to the appointment to the board now, it goes to the Governor General in Council on the recommendation of the board.
That's what my understanding. How do we treat with this, the appointment of the senior deputy governor then?
Senior Deputy Governor is on page 8, the bottom of page 8, section 9A.
Yes.
Senior Deputy Governor is appointed by the Governor General and Council upon the recommendation of the board. So it's elevating the appointment of the directors to the same level of kind of prominence as the appointment of the governor, right? So they get their seal and their whatever. So they are as... They have a different function, but they are as important as the governor. Meaning, you understand what I'm saying? In terms of the it's symbolic. In terms of the method of their appointment. It's not the Governor General is appointing the governor, but the Governor General is also appointing the members of the board.
Governor General
in council. In council. Yeah.
Just you said again. Apologize. I don't have how the governor was appointed, but it's essentially the same as the senior deputy governor, right? We said governor and senior deputy governor, the same method.
Currently, under the law as it stands now, or under the bill?
Well, both if it's different.
Well, in the bill, it's not identical because the Governor General and Council appoints the governor, which is a cabinet. Whereas a senior deputy governor is appointed by that, but on the recommendation
of the board.
Of the board, after consulting with the minister.
If the question is how the senior deputy governors are now, governor is now appointed, this is by the minister on the recommendation of the board. So currently, governor is Governor General in Council. Senior deputy governor and deputy governors are appointed by the minister on the recommendation of the board. That's the current dispensation.
Right, but the Governor General in Council, is it after consultation with the minister?
No.
So what I'm trying to understand, and maybe the drafting.
No, I know. I see where you're going. Can I just try to answer you? Because you had asked it before and it wasn't that. So you're looking at section 9 of the bill,
right?
Where you're seeing in the last part of it, it says, on such terms or conditions as may it be determined by the board after consultation with the minister. My understanding of this is on the conditions and terms. That is what you consult with the minister on.
So the consultation with the minister only refers to the on such terms and conditions?
Yes. That is the intent.
And that only applies to the senior deputy governor? That regime? No. That's an anomaly, surely.
Chairman.
Yeah, this is the person being paid. So there's a contract.
How much the person is being given?
So it's saying the board sets it, but they must consult with the minister on that.
Chairman, I understood.
The terms of the governor. Did we change the?
Chairman, I understood.
These are laid out as we go through the clause by clause. It may be that you should go through.
But it's useful to deal with this. Yeah, as a scheme, you know.
Yes, but not the details.
I understood, Chairman, that we're taking the minister out and we're going to independence. When we spoke about the Public Bodies Management and Accountability Act, we didn't want it to apply. We didn't want it to apply to the BOJ. They didn't want it to apply to them. But that is where the issue. That is where the issue of setting a salary came in. But here we know we're going to take the senior governor, our deputy governor, and apply a salary set by the minister. But in the rest of the bank, it's the bank that determines.
Because you don't want for the minister to set the top one, so it sets it limits.
I want first.
We're not saying set by the minister; it's set by the board. But
I want first consistency. If we're taking the minister out totally, we can have the minister into peace. So we need to be clear whether the minister is going to be in peace and not the rest, or the minister is going to be in all or none. That's where my thinking is right now on it.
Chair, could I just clarify that when we say taking the minister out in terms of the staff generally, the aim in the language, and you'll see when you look at it, is that the board will be empowered to do what it thinks it should do, but where it's going to deviate from the guidelines set by the minister, then it has to consult with the minister. So we're applying the same sort of concept here to say the board should make those decisions, it should be free to, but if it's going to, in this case, there's no guideline for a senior deputy governor. This is a person appointed basically by the government. So these particular jobs here at the top, the setting of salary can't be by the same people, who run the place, if you understand what I'm getting at. So that's why there's a different treatment to the SDG, and there should be to the governor and any of those executives, because they will be in the room setting the compensation at the board.
This is fake independence. This is fake independence. Independence in part, but freedom in the bigger part.
You don't have to answer
Senator
to
Brown,
that. You don't have to answer to that one.
No, I need an answer to it. I need an answer because what the country is seeing is at the top of the bank, the second tier person is going to have the salary set after consultation with the minister. The other people in the bank doesn't fall from that. But do we get some relativity? So in the salary, so in effect, by intervening through consultative process at the senior deputy, the minister is setting the rest.
I think what I was trying to clarify is that in what we propose, and that's not yet agreed, but you are looking at that in the proposed regulations, since we're proposing to be removed from the PBMA and other changes here, there's a proposal that in setting salaries, by the board setting the salaries for the bank, that it, in a sense, the idea is to, not to get into drafting, but the idea is that the bank should follow the guidelines of the government if it can. If it's not going to, it can go ahead with what it needs to do, but it needs to consult with the minister before it goes that route. That's all. That's what's being done for the staff of the bank, and the idea is that a similar structure is being done for the board. So it's the same. The intent is to achieve the same sort of independence, but consultation, if where it's in an appropriate.
So Senator Brown, just before you, we're trying to balance a lot of things. At the last meeting, it was either you or Senator Gale who mentioned the challenge in a society like Jamaica, where you have special institutions where the pay can be higher than is general, even though that doesn't really apply to the BOJ relative to the market it is competing for talent in. And that was in response to the discussion at that time that the board could set the salaries. By having consultation with the minister, it just allows for some balance that we don't end up with something being unhinged, being totally divorced from the society in which the institution exists. The primary focus of independence in this bill is on independence in the conduct of monetary policy, and we are achieving that. The bill achieves that, in as much as the 2014 amendment achieved independence in the supervisory function of the BOJ. So this bill, in combination with what exists today, with respect to independence, squarely achieves independence on supervisory matters, independence on monetary policy conduct. And in the setting of salaries, we go a long way to achieving independent status, but always, if the committee so agrees, with having just some reference, some consultation, if you're going to go out, right? You don't hear it on the radio first, and other people getting upset, and it having an effect that having repercussions that were not anticipated. The minister is in touch with the broader society, the 100,000 people working in public service, is aware of what the public body pays are, aware of what the teachers, nurses, and so it just allows for that balance.
Minister, I think you're preaching to the converted.
Well, I'm not so sure that I'm converted. I want to be clear.
Well,
sorry, Pedro.
All right. All right. Well, my own view is that, particularly in a small economy, there are many public sector entities that could claim that they're not competing. A petrojam refinery engineer. There's no other.
You said that? Is that on tape?
There is no other. There is no other employer of refinery engineers in Jamaica than Petrojam. So they could claim, look, we're not competing in the local market.
There's LNG now in Jamaica. LNG,
we're
fuel.
competing in the international market. So therefore, you must pay our refinery engineers at the international basis. And, so then you go to the port authority. There's only one port authority in Jamaica. They make the argument and so on. So I believe there must be a check and balance, particularly in an entity whose ability to pay is virtually unlimited. Is unlimited.
They just charge you,
right?
Or
for
charge
all
us.
intents and purposes. But ultimately, the profits and losses are for the account of the taxpayer, and therefore, to me, without having the check of the minister, and I think, by the way, the clause is a bit ambiguous for a lame person. I would like it to be.
I think she agrees as well. The draft.
Yeah, I think for the lay person it would be clearer if the terms and conditions would be set out in a separate sentence, so that it makes it clear. You're right. So it makes it clear.
The consultation with the minister is only to apply to that. That's
right.
The intention. Well,
but how it reads now, that's not clear to me. That it's only for the terms and conditions.
Especially that comma, SG.
But I believe, Mr. Chairman, unless we have that, then what we would breach the principle of no taxation without representation.
No, absolutely, and that's why it's there. I totally agree with you on that.
So I think that must be there. I am not of the view that independence goes to independence to set your own salary as you like. That no system can run so. So I strongly support that, but I would just like it to be clearer that in how we draft this clause, that it's that it applies to everybody who is an executive, and that it applies just to the terms and conditions and not to the rest of the appointment process.
If it goes to everybody, you would have converted me to it, because it can't be that the PBMA is not applicable there. But we can.
So you want it to apply not just to the senior deputy, but to the deputy and the. Is that what you're saying? And to the governor.
And I'm a little worried. I must say, I'm a little worried about mere consultation, because these lawyers will tell us that
But all I need to do
is
show you,
are just to advise you, and that is consultation.
and then move on, so that maybe we need to move
after
beyond
approval.
just mere consultation
After approval.
here.
Approval, yeah.
And to say what the PBMA says, with minister responsible for the public service must have a role to play. You can give the big salary if you want. There's consequence from the teachers and the police and so forth if you give them a little bit and give others big. Your decision, but I can't see it being applied just to one. It must go down. Your decision have to approve. You should approve it.
I don't absolve the minister can't absolve himself from the situation.
Yeah. Council Chair, if I could just ask the council in terms of the governor, is the governor's appointment on terms and conditions, the salary and terms and conditions, how is that work? Does the minister have a role in that?
Yes. When we get to that part, it's the same
formulation.
Purpose. Yeah. So we'll.
Yeah. And that's in the BSA now?
No.
Schedule?
That is in the proposal here at section. Where is it?
Here, I understand that there are some. Sorry.
Section.
Could I mention that page 7 of the bill speaks to the matter of the governor? In the current statute, while it says the governor shall be appointed by Governor General in Council, it didn't go on to talk about the terms and conditions. So for consistency, that has been placed at page 7 at clause 6. Clause 6, and it's at subclause 3 of 6A, which says a person appointed as governor shall hold office for a term of 5 years and may be reappointed. Such appointment shall be on such terms and conditions as may be determined by the minister after consultation with the directors of the board.
So it's determined by the minister after consultation.
Yeah. But it's kind of weird to have all these nuanced differences for different posts. Why not have one? I mean, why is the senior deputy thing not following the same model? Yeah.
No, but the senior deputy.
In the redraft, we could put. Go ahead.
I just wanted to confirm, Chair, on page 9, are we doing the same amendment to 1A as we did to subsection 1? We're going to separate the provision so that the terms and conditions are going to be determined by the board, not the appointment. We're going to do the same thing that we suggested.
From a drafting perspective.
Yes, fine.
Yes.
So that, and then on the same one that we were just discussing, are we doing the same thing with respect to the governor? We're going to.
It would be consistent to separate it.
Okay.
Yeah.
There's a separate issue from the drafting point, which is
to consolidate
what is the
it.
scheme.
Yes.
And
you're making a point that's not drafting now, which is the point you just made. I think we should.
I mean, the point was that the governor's emoluments are determined under subsection 3, or will be, right? Which are determined by the minister having consulted with the directors of the board. And why should that not also apply to the others? Yeah.
It should be done the same way. The same language shall be in such terms and conditions as may be determined by the. It's actually different for the senior deputy governor.
Yeah.
Make it the same.
Yes, Chair. From where
I apply
sit
to governor, senior deputy governor, and deputy.
From where I sit, Chair, whatever is good for the goose is good for the gander.
Yeah.
Thank you for that, sir.
Can we clarify, though, if I may? Chair, the
biggest antagonizer.
So, Chair, if I may just make sure I understand, or maybe clarify what I think the governor, the senior deputy governor, deputy governors. There, I'd like to make a distinction because those are the deputy governors who are not on the board are in the new dispensation appointees of the bank. They are just senior officers. There are division chiefs, there are other levels below. So this is a change here. They're not appointed by the minister. So they would fall within the rubric of the staff of the bank, essentially, and the compensation policies. And those fall within that general language that we haven't got to yet, but is being proposed in the regulations that will ensure that the setting of salaries for posts and the setting of and paying of individuals who are in those posts would be under the control directly of the board. They would comply with guidelines of the government where there are any, and if they deviate, if they expect to deviate, they should first consult with the minister. So that you want to deal here, I believe, with the board, the people at the board level, not people below the board. So one of these board members is a deputy governor who is being paid as a full-time person as a staff member, and he's now just being elevated to the board, he won't get paid for that separately.
You're suggesting it should be putting them together should be governor and senior deputy governor.
Yes.
And then the regulations now would apply to the deputy governor all the way down. That if you deviate
exactly.
from government policy,
Exactly.
you consult with the minister.
Exactly.
So,
So I can't get rid of Senator Gale then? Huh?
With you for life.
I'm still not clear as to what is the final decision as to how we rephrase.
We're still working on it. The final,
okay.
it would be to put the governor and the senior deputy governors.
I stepped outside my brief. So just to be clear, the proposals here do cover the deputy governors. So I just want to be clear in what I said. It was my view, but what is before us here in the legislation at page 9 proposes that for the deputy governors who shall be appointed by the board upon the recommendation of the governor by instrument in writing for a period not exceeding 5 years, this is all similar to what we had before except for the appointment, but on such terms and conditions as may be determined by the board acting upon the recommendation. No, that is what I said.
Yeah, but you said it shouldn't be in the statute. You said it should come under the provision.
No, sorry.
Let's just keep it consistent. So we'll change this just to your suggestion. I think it's if we keep it consistent, Governor, for the governor, the senior deputy governor, and the deputy governor, when it comes to the terms and conditions, we use the language, such terms and conditions as may be determined by the minister after consultation with the directors of the board. Is that?
The other way around would be better, maybe.
Well, that's how, the way we had it for the governor.
Yes. Governor being different.
Yeah. No,
yeah.
No. Keep it the same for the four, is what we're hearing from the committee. I mean, it puts more pressure on the minister because the minister has to justify the high, if there are salaries that have to be competitive and are high, the minister has to justify that, and that can be challenging from time to time. But it's probably the better scheme so that we, the easiest way for the central bank to lose credibility to the public would be for some runaway salary that nobody was really aware of, and it becomes public it gets exposed.
It exposed the minister, it exposed those who even bargain with the central bank.
Yes.
But one point I want to make, Chair, because
before we move on, if I could ask a member, could I just be sure I'm clear? Governor, senior deputy governor, by the minister on the recommendation of the board for pay. No, not
this is just a term. We recognize that the deputy governor is appointed by the board.
Say again, please.
The deputy governor is appointed by the board.
The deputy governor who is appointed to the board is appointed by the. Sorry, yes, deputy governors are appointed by the board.
Right. So that deputy governor should be.
No, all deputy governors are appointed by the board.
Wherever you're dealing with the terms and conditions in this bill, we want them to be the same. Wherever you're dealing with terms and conditions, and I believe you're dealing with terms and conditions for the governor, for the senior deputy governor, and for the deputy governor on the board.
Okay. Could I just say one thing here, Chair? The deputy governor who is appointed to the board is a board appointment, which, for want of a better word, there would be no terms and conditions attaching to that. They're not paid for that. That's not a substantive position. So my suggestion is that if what you're saying is that the governor and senior deputy governor together who are appointed by the governor general in council, then the terms and conditions should be the minister on the recommendation of the board. That's what you said, right?
No,
we're not focused on whether the deputy governor is a board member or not. We're just saying the deputy governors, the senior deputy governor, and the governor himself, so their terms and conditions are set by the minister in consultation with the board.
Right. Yeah. Specific to terms and conditions now.
Right. So the only point I wanted to raise was that the deputy governors' appointments are done differently from the other two.
Yes, I would not change in that. It's just the terms and conditions, and there's a strong argument. I can understand the counter as well. but to the extent that we have to make adjustments, there should be adjustments that the minister is aware of and approves of, right? Because of the implications in our society, just the reality. I understand the counters, but let's move with that for now. Okay? I think let's move with that for now. I can see the governor is a little perplexed.
Well, I'm just reflecting on the fact that those deputy governors not on the board are staff, effectively. They're not different in employment, etc.
But think about where we are now, though. Think about the transition, right? Right now, the minister appoints the deputy governors for all intents and purposes and sets the salaries. We're moving now to a scheme where the minister does not appoint the deputy governor, has nothing. It could be John Brown. The minister doesn't have any say in who it is. But we're just retaining the minister's involvement in the terms and conditions because of the nature of the society, right? We have, believe me.
My hesitation, Minister, is that
it would be to change consultation to recommendation. In other words, to give the board a little bit more say, though it's ultimately the minister's decision, and the minister could at least say, I acted on a recommendation of the board when I did this. I didn't just come up with a figure and then consult.
Chairman,
though ultimately that's his call, but I think it gives the minister a little bit more protection in terms of dealing with the issue.
Chairman, I like that one, and let me tell you why I like that one. For the central bank, you have to treat with competitiveness, the evolution of private sector salary, and to be able to attract and to retain, and the whole integrity of the internal salary structure. So if the board, having done its reviews and its surveys, recommends to the minister, it is different from just to consult with the minister. To the board, yes. Consult with the board.
I don't understand. Recommend.
Right. So the board would now recommend.
Or the minister does not have to take the recommendation.
A higher level of authority.
But the minister doesn't have to take the recommendation.
No.
Because recommendations from time to time can be way outside of the scheme.
Yes, right. But it's still the determining factor is still the minister. What the minister decides.
The minister accept the recommendation. No, but at least it's something that is weighed in.
I think it's how it's drafted. If it says upon the recommendation, then it might oblige
we already addressed the issue that those formulations need to be
right. But if we say after receiving recommendations, then it's a different thing rather than upon the recommendation. These are technicalities that the CPC can work out.
Recall that we've written out, so we're going to define what these words recommend, so on. No, it was based on a previous discussion.
We'll do that at the end. We do that at the end when we understand all the implications of it.
Yeah.
When we're clear what we're trying to achieve.
Yes. And Chair, I think you looked at my consternation. I think that proposal...
Recommendation you're more comfortable with than...
Absolutely. I think it allows for the interplay of the different interests and then the decision making ultimately, but on a basis of
ultimately,
of knowing what you need
the minister doesn't. He can say to them, "I hear your recommendation. Yeah. I'm not happy with it.
Right.
Please, these are the reasons I'm not happy. Yeah. Go and think about it again and come back to me." Or he can actually ultimately make his own decision. Exactly. But then he's accountable for the decision he made if he hasn't followed their recommendation.
Yes. Chair, I think that would balance. Concern here. Sorry,
that would balance those interests. I think. Sorry.
No, there's one concern here. In a normal scheme, that minister could fire the board if they didn't it. In this scheme. Minister can't touch the board.
True.
So that's a factor we must take into account. So the board just say, Minister, you talk foolishness. We're moving ahead. So that's a factor we have to take into account because here this board kind of permanent.
But this has given though he doesn't have a say in the composition of the board, he does have a say in the salaries, which are part of the cost base of the bank that ultimately impact the consolidated fund ultimately. So he must have the final say in the matter. It's not a binding recommendation.
As long as recommendation is understood to be not something that binds, that you are free to do, because in the context of, let's example, the whole of the society has a wage freeze, and somebody comes with a recommendation that says, look, boy, competitiveness, da-da-da-da-da-da. I mean...
I want to hire Carney, from...
Exactly. The minister has to have the right to say, no, I hear you, but the rest of the society is experiencing this, therefore, yes, he's Canadian, is all that? Mark Carney? Are you serious? Small world. Wow.
Samantha Fox.
We're making a number of recommendations.
Could have been you.
We're making a number of recommendations throughout these deliberations. How can we red flag it so that when we get to some of they're taking notes?
Yeah, taking notes on it. All right, so we will look at it with the language of recommendation, and then let's see what it looks like. We dealt with a number of clauses by virtue of doing that. So I think we are now on C. This is just a clause that just makes sure that the deputy governor's term as an employee and the deputy governor, there's no conflict between that and the deputy governor's term as a director. So,
is that not already addressed somewhere?
Well, it's in C. It just says the appointment to the board, that deputy governor on the board can't be appointed for a period that is longer than the term of the remaining term under his or her contract. Is it covered? Yes. Yeah. And if we go to D, it makes it that if you're no longer, the deputy governor is no longer deputy governor, that person can't remain on the board. That's straightforward. And then E deals with termination of a director.
That's only for the 5 appointed.
Only for the 5. So the director, as Senator Brown is saying, the director is there for their appointment.
Clarify C and D. Is it that somebody could be convicted for dishonesty but not sentenced? As again, C is convicted and sentenced to a term of imprisonment. I mean, somebody provoked and used an expletive. That would be enough to get them off the board.
Kind of a high bar. It's a very, very high bar.
You
right?
can't be sentenced to a term of imprisonment without being convicted. So I think that's why C is worded that way. But D doesn't matter whether you were fined or you may have got community service. But if you were convicted of an offense involving dishonesty, that would be
that.
Yeah.
But are we going so low as no limit on the imprisonment, for example? Because if somebody used an expletive, that could be
that's spliff, back in the days of spliff, before Senator Golding.
And usually to serve a term of imprisonment on conviction.
No, this says if you're sentenced to any form of imprisonment, if it could be a day.
Right. But you don't get incarceration on a first offense if it's a light matter. This is a language that yes, but then a judge believes you've done something that deserves it. The question is, if you've been found guilty of that and a judge has convicted you and under the law, then should you sit on this board? And that's really, or should the Governor General and Council be able to remove you? And I think that there should not be a debate there that if you're in that position, that the authorities can remove you. Whether they choose to is another question. It's not automatic. And there may be mitigating factors. But there was a point made by Member Golding at this part that we thought we should respond on.
Yeah, I had made reference to there's an additional criteria that was in another part of the BOJ Act, which was to do with, it's set out in my little note there. Where is it?
Yes, we agree.
Yeah, so maybe you could respond to that. Yeah.
Yes. So Member Golding suggested the addition of engages in activities that can be reasonably considered to be incompatible with his continuing as a director on the board.
Yeah, but it's in another part of that.
That's very broad.
Yes, and in fact,
though.
Chair, this is similar to wording that is later in the bill for the MPC and the FPC. Just so that was the same
That's
language.
already in the act.
Yes, yes.
You haven't committed a crime, you haven't done anything wrong, but you're doing something that could reasonably be seen to be incompatible with the opposition. It's not a clear conflict, but it's inappropriate in some way.
Supposing you engage in some conduct in business, or you go into a financial, you buy a majority shareholding in a regulated entity, or them, or you're something which is really not appropriate for somebody who's
right, and then you can't get them off. You're stuck.
Yeah.
I could point to an example, building on what Member Golden mentioned. Let's assume you've bought into a company that doesn't have a license. It's not regulated, but it's about to get one. And so you put yourself in a position where there isn't yet a conflict, but there will be one. How do you address that? What is the basis? And this kind of thing allows you to. We think it's a useful wording. We're open to that inclusion, I think.
Okay.
Yeah.
Fair enough. So we put that in there. Section 6 of the bill, we just dealt with that. That was a part of the.
There was a comment that I had made. On this, it really to do with the tenure of the directors, the appointed directors, the 5, and how they're tenured. So I guess you have a response to that at some point.
Yeah, that's later on.
I raised it.
You had raised it here, but
you'll deal with it
later on when we come to the tenure.
It's in the schedule, I think.
Yeah.
Yeah.
So I think we're on to 7.
The term of the.
Which is what happens in terms of what happens with the stewardship of the bank. You want to read? You want to?
Chair, the team is catching up.
The governor, or in his absence, the senior deputy governor, or in the absence of the governor and the senior deputy governor, a deputy governor designated by the board after consultation with the minister shall be in charge of the day-to-day management operations of the bank and shall be answerable to the board for his acts and decisions. So it goes from the governor to the senior deputy governor, and if it is to go to a deputy, the minister gets involved. Is that? And then section B, in addition to the day-to-day management and operations of the bank, the governor shall have such other responsibilities and functions as are vested in him under and by virtue of the provisions of this Act and any regulations made under this Act, the Banking Services Act, and any other enactment. Section 8, or Clause 8, Section 6C of this Principal Act is amended as follows by deleting a marginal note. Well, that's elementary. That's just changing a marginal note. Clause 9.
The inclusion of the senior deputy governor as part of Clause 6C was just providing that he's dealt with the same way.
Yeah, and that's now by the minister on the recommendation of the board. Sorry, Governor General and Council instead of by the minister on recommendation of the board. And
right.
The points made.
9A we have dealt with. Clause 9A of the bill, which we discussed, terms and conditions, and we'll make the changes that were recommended.
One question, sorry. In the formulation where it speaks to terms and conditions, is that intended to include salary?
Yes.
Your thing was emoluments, make it broader than salary.
Terms and conditions, because typically terms and conditions are contractual arrangements around all sorts of things,
right.
Whereas the key issue of compensation.
Emoluments is broader.
Yeah. I just you could add it, the same emoluments, terms and conditions.
You got that, CBC?
Are we adding that to 1A? Isn't this an appointment to the board we're speaking about?
No.
Right, I am not at 1A. I was distracted when you moved on. I am just at the wherever we talk about the terms and conditions issue for the governor, the senior deputy, and the DGs, that where we talk about terms and conditions, we should say emoluments, terms and conditions, just to make it
broader than salary.
Emoluments and on such other terms and conditions, I think was your language.
No, we're not on 1A yet.
Yes, it's everywhere where we're dealing with terms and conditions.
Thought I was loud enough. Right, so the terms, section 7 of the Act itself talks about when you appoint staff, including officers and so, who I assume would include the deputy governors, and it talks about employing them and it deals with remuneration, terms and conditions. Is it then that when the same officers, staff, are then appointed by the board? I don't understand how 1A on page 9 of the bill will fit in, because it then talks about terms and conditions, and you are saying add emoluments, but that was already addressed. But he said terms and conditions, including emoluments.
I think that 7.1 is superseded by this in relation to the deputy governors, because 7.1 is an appointment regime, which is inconsistent with 1A. Completely.
It is.
I think that 7.1 needs to be taken into account, that 7.1 will no longer apply to the deputy governors.
But there is no amendment to 7.1.
Well, that needs to be addressed.
Except to say delete the word subject to. So this is why we are now we're a little confused about the regime then.
Well, the regime coming out of today's meeting appears to be that the...
Seek a clarification. If I thought what I understood earlier and the concern that was being expressed by Mrs. Chinqui Aiken was the very fact that this scheme of employment which exists in respect of the deputies, wherein there is no additional emoluments or any other remuneration that's addressed to their appointment. The appointment is a mere appointment, and that was part of why they were being treated separately from the senior deputy and the governor, who are appointed by the Governor General and Council. And that was why they were somewhat reluctant to change the mechanism here to one which involves the minister, because they were saying they're employees. They're employees that are treated within the normal framework within which they employ persons. And the question was whether, therefore, what was seeming to be quote-unquote cohesion or harmonization of language, because they were all deputies, was in fact running contrary to how it is that employees are treated with. And would you then be creating a new problem about a lack of clarity around their status? And that seems to be borne out by the clause 7, which isn't here because it's in the Principal Act, and it's therefore, we're not privy to the full scheme. So is it then that we need to be reviewing the position that was taken earlier, which was being discussed without the context of section 7 as it exists, and that we need to keep that as it was, and keep so that the deputies who are employees versus senior deputy and governor, that we treated them differently?
Well, I don't think so, because under the bill that's before us, the deputy governors have an appointment regime in the bill now, in this bill, as does the senior deputy. Only one of the deputy governors happens to also go on the board. That doesn't affect their remuneration at all. But the deputy governors as a whole are appointed under this bill. It will be a regime for that. And we have said that for all persons who are appointed under this bill, so to speak, the terms and conditions of their employment will be set in a particular way. 7, as it's worded, would seem to also apply to the senior deputy governor, because it says the bank may appoint an employee at such remuneration and such terms and conditions as it thinks fit, such officers, agents, and servants as the board considers necessary. It's not limited to deputy governors as such. So, or even the governor. So I think 7 needs to be subject to the provisions that we are adding now in this bill. And these provisions, I think, would apply to deputy governors, senior deputy governor, and the governor himself, all of whom would be appointed in slightly different ways, but their terms and conditions will be set in the same way.
No, agreed. And the reason why the deputy governors need to be in there is that once you have them out, then the argument, hey, that's what deputy governors are getting, therefore the senior deputy has to get this. You know, so you have to get all the executives in one scheme. Yeah. So the change here was just to make sure we substitute emoluments. That's what we're discussing right now. Putting emoluments as a broader word.
And such other terms and conditions.
Yes.
Yeah.
Okay, so that brings us to, no, not 1A, it brings us to 1B. And this is just, you have a supervisor who is the supervisor of banks, and you have a deputy supervisor. The supervisor is usually the governor. And if, you know, the law requires a deputy supervisor, you want to make sure that if that deputy supervisor is a deputy governor, that there is synchronicity in their terms of appointment. Correct?
Yes, and there are special features to the deputy supervisor appointment put into the law to make sure that when you appoint a deputy supervisor, that their term of office should not end within, I believe it was 12 months of the end of the term of office of the supervisor. That was the provision.
This point is only dealing with the duration of their term of office. That's all this is dealing with. And saying that we shouldn't have an inconsistency between how they are, the term for which they are appointed deputy supervisor, deputy supervisor and the term for which they are appointed deputy governor.
Yes,
okay.
and
that brings us to C. Subject to subsection 4, in any case where a deputy governor who was not previously carrying out the functions of deputy supervisor is appointed as deputy supervisor during the term of the deputy governor's appointment, the appointment as deputy governor shall be deemed to have expired, and his new appointment as deputy governor and appointment as deputy supervisor shall commence. So where they are seen as not synchronous, then you kind of do a reordering to make them synchronous, right?
Is there a clarity on what will happen to the existing incumbents? I mean, there's a transitional arrangement. Sorry, it may be in here. I just wanted to.
And once this bill comes into effect?
Yeah.
Let's get close to bringing it into effect. But yeah, that's something to think about. From the board, from the directors on down. That applies from the directors down, right? Because, you know, it's a punctuated change. You have a new law that has different methods of appointment. So we would have to appoint everybody over, I would think, certainly under the new act, under the new dispensation.
Well, for the board members or the staff?
No. For the board members.
For the board members?
Yeah.
Yeah.
But
is there anything in here that deals with that? There's no. All right. So there's no transitional provision currently in the bill. So there needs to be something. You need to think through what you want for that. Yeah. Do you want that when the bill comes into effect, all board positions are vacant and you make a new set of appointments under the new regime? Do you take into account how long they've been serving so far towards the period of their thing? You know, these issues need to be.
No, it needs to be thought through. And put a transitional clause in there.
Up to this point, and it can do with further thinking. But the thought was this would be for the board. This would be a new board, and there's no restriction on reappointing people. It's a new dispensation when it starts for the appointed members of the board. That was the thinking. It does bear carefully rethinking and going at it again. I agree with that, but that was the thinking. The issue raised that relates to these employees. I mean, people have contracts like a governor, a senior deputy governor, and so forth. I think those. I need to just check what we had. I think those require a little care. With respect to the deputy supervisor, which was the issue here, just to note that they're already aligned. in the current situation. Yeah.
But this is just making sure that if they were to ever be misaligned.
And it could change, things can happen, so I agree with the point, yeah.
We'll hear back what the transition arrangement for the executive staff are, right? Yeah. And also for the board, if it is that the board is being reappointed, as it were, as a new appointment, given the tenure arrangements that we're talking about, should their most recent term that they've been there be considered, because you're going to be giving them another big period of time, and that's right, yeah.
When you have regard to the practicalities of the fact that the initial proposed appointments are 2, 4, 6, 8, 10, and you're looking at actual people, from a practical point of view, you may find that some of this
after all this fit and proper stuff that we're putting in, right? To finding people to fill all these positions, the 5 board members, the 2 MPC, the 2 FPC, the 2 SC, we have about 12
SC, 2 FSSC. There's 8 appointed
believe
members,
me, with the
plus
conflict
the
of interest thing, very difficult.
Well, only 5 appointed directors out of the 8, right?
5 appointed directors and 8 appointed members of the various committees.
Oh,
13 people in all.
13
and they
outsiders.
can't be one and the same. They're not allowed to be one and the
They
same.
can't be this. Well, board members can't be on them.
Is that precluded? That's precluded?
Yes, but in terms of can an FPC member be an MPC member, that is not written in, I believe.
Okay.
The thinking is that they wouldn't be the same people, but that's something. Well, we could think about that.
That maybe should be addressed if you want to have them not cover the same.
They're not meant to be the same. No, they're meant to not be the same. Yeah.
Well, if they're meant to not be the same, they should say so.
Because the committees are separate and trying to.
Because we don't want to make the ministers' work easier.
To be clear,
cut the number in half. Let's appoint them to both.
No, I'm sure that will be welcome. But bear in mind that
now that you mention it,
the committees have a lot of overlap in the executives. So the idea of these appointed members is that's what breaks up the sort of groupthink that might arise and allows the outside authority, the government, to then, through this process, be able to have some insight or influence through these appointments on the direction of what the bank's doing in each of those specific areas.
And it definitely would not be conducive to broader views being brought to bear if the same externals are on both committees. That's not ideal. Yeah.
Time they spend in the bank, the more they.
Okay, in subsection D of 9, this deals with the termination of a deputy governor, similar to what was there before, and so it will be consistent to make the same amendment, that if the person is engaged in activities that are contrary. Yeah. And that would bring us to clause 10. Section 7 of the Principal Act is amended as follows in subsection 1 by deleting the following, subject to subsection 2, and substituting therefore the word the. Just the effect of this?
I think we would have to insert another provision to exclude the appointments of the persons who we are doing under this bill, the deputy governor, the senior deputy. So we'll put in a subclause 1A to exclude them from subsection 1, the provisions of subsection 1, because we have dealt with their terms and appointments separately under this bill.
Yes, good catch, yes. So 10, clause 10, you just want to, this is not a material change.
Clause 10 is significant, I think, Minister. Yes. This is the segment. To do with the salaries. Sorry, clause 10, which is section 7. This amendment is what removes this statutory power of the minister over salaries across the bank and over positions, and that's the provision that by eliminating those 2 subsections, we then need to then put in the regulations the provisions.
Yes.
The provisions in the regulations that I mentioned a little earlier that would establish the obligation or duty of the board to ensure that the bank is staffed appropriately so that it can meet its mandate, and provide for policies on employment and so forth, pay, etc., that would allow them to meet their mandates, but if the board decides to apply terms, conditions, pay, etc., that would be outside of the guidelines that might be set by the minister from time to time for the public sector, then they would be required to, before implementing a change, consult with the minister. That's the provision I was speaking about.
I know the subsection 4 of it had 200.
But shouldn't 7.1 require that the that the appointments be in accordance with such regime as may be prescribed. In other words, if you're going to have a set of regulations governing the approach to setting this thing, 7.1 ought to reference it in some way, you know?
Yes.
Because as it stands,
Yes.
even if you delete those words at the beginning of it, it just says the bank may appoint an employee at such remuneration on such terms and conditions as it thinks fit, you know, such officers, agents, and servants as the board considers necessary. You know, so I think
it should be consistent. It should refer to some of the
to the prescribed
refer to the
regime that you're
regulations,
going to be
prescribed.
Yeah.
Yes. So what language?
Yeah, boy, the fact that the $200,000 is still there.
Yes, somebody owes you some money.
We did some research to try and find. Sometimes the change is in instrument somewhere, and we couldn't actually find. We couldn't find it. It's a letter. I think there are various ways that the public sector writes to everybody, and we couldn't find anything.
That letter, if that letter isn't found, you know, come and talk to me.
No, we're going to have some, what do you call it? Those backward-looking things, validation. You take it a contingency. But if you were to do that, I think your hands would be full. I suspect we have a lot of these things.
These are the provisions that stop an institution from doing anything on pay once it's above these levels without, in line with the public sector ministry, which is a control function that I think we all recognize as important. And therefore, how do you balance that interest of the, broad, consistent policies across public sector, but allowing the bank to proceed?
Okay. And
assuming its union is in agreement.
That's why review periods are very important.
Yes. Senator Gale, I understand that. All right, Section 11 now deals with the authorized capital of the bank, and here another number was in the bill from a long time ago. The authorized capital was set at $2 million, which is entirely inappropriate for today's Jamaica, and it's been proposed that it be changed to $28 billion.
Chairman, just for clarity, how we arrive at 28 billion?
As opposed to 30 or 26. 35. You want to explain that, Governor? Do you have enough capital when you do this now?
I think the number for paid-up capital is 22.6 billion. That's here.
But authorizes the maximum you can have, right? So why 28 and not 32?
Yes.
It doesn't mean it's authorized. It doesn't mean that that's the capital you have. Why? Can you answer Senator Gale? And I'm sure other members have the same question. Yeah. What's the magic of 28?
Yes, and I can be clear. There's no absolute magic to the 28. It's a buffer above. The calculated figure is the 5% of monetary liabilities as at December 31st, 2018, and that's what we think should be the paid up, and then some buffer above that in the authorized capital, so you don't have to come back.
Can I just make one point
the paid up is 23. I mean, normally, certainly in the private sector, your authorized is a lot higher than your paid up.
Also, since 2004, our company law allows companies to be established with unlimited authorized capital. So you don't have to get approval to increase your capital. You can put a limit if you want. I mean, the question really is, why are we importing a regime into this modernized statute that requires some artificial cap on authorized capital to be set? There's no question of dilution here because there's only one shareholder, which is the people of Jamaica. So why do we need an authorized capital? What matters is what the capital of the bank is, and is it sufficient?
No, I agree.
We think that's a parliamentary control question.
No,
it's not.
The paid-up capital, no problem. That has to come for approval. But the authorized capital, there's no reason. Yeah.
And indeed, if I can say, the scheme that we're setting up here generates movements in the actual amount of capital that could be much higher than this as earnings are retained.
Introduce another complication that we have to amend the bill.
I think the issue here is that we'd have to make because the scheme that is imported is not being imported. It's the scheme that's already there. So what we're doing is leaving that concept there and adjusting it, rather than trying to change that authorized paid-up concept. That's really what's happening here. I think it is a good point as to whether you need this sort of thing at all. And that's, as I said, it's a part of the parliamentary control scheme that we had that can be changed. I don't think it's a policy issue.
In a corporate setting for authorized capital is to allow shareholders a say on whether there will be increases which might dilute their position. That's the main role that it has. In this instance, it really doesn't. That's not really relevant.
Especially because we're going towards a dynamic capitalization regime. So
as long as if a call is made for additional capital, which is going to be charged, paid out of the consolidated fund, that there's a proper governance arrangement around that, transparency and decision making, so that and I think that's what the bill seeks to do. To go and have to set some artificial limit on authorized capital and then have a regime for changing the artificial limit to another one just seems kind of redundant now. And I think that's what was, this comes out of an era when shares had par value and the whole thinking around nominal capital was very different to what it is now. Yeah.
I'm okay with that. It's the CPC here.
I think with that guidance, would you want us to take a look? It's not just drafting so much as looking at what we need to change in this.
Please.
To sort of eliminate authorized capital concepts.
Please.
And just leave us with what is authorized here in this section as the paid up, and then the mechanism we have for recapitalization, which is we'll see in a bit, that requires recapitalization when it falls below 3%. I'm
assuming that the recapitalization, both the capitalization and recapitalization provisions, can work without this authorized capital concept being part of it, and that it's not going to be any major surgery to eliminate it. But I think that needs to be checked. Yeah.
We'll just have a word with our auditors and accountants just to see if there are any implications that we haven't thought about. Yeah.
Okay. On section B, subsection B of 11, this is dealing with the paid-up capital, and in the existing act, the paid-up capital is $500,000, and it's been proposed on or before the day on which this act comes into operation, there shall be paid by the government by issue to the bank marketable securities in respect of such capital in a sum of $22,640 million. Governor, can you just shed some light how you calculated that amount? I mean, the idea is to have sufficient capital. Is this 5% of the monetary liabilities as at?
Yes, it is.
Such and such a date?
In December 2018.
December 2018.
Yeah. So it's based on actual numbers.
Right. And international guidance being between 3 and 8, and we've chosen the midpoint.
With 5 as the norm, as the target.
Well, actually, just below the midpoint.
Yeah, it's more 5 as the norm, and then those ranges 3 and 8 are convenient numbers to guide some certainty to distribution.
Right. And just to be clear, the recapitalization that we have done in this year's budget and the budget before, this was to address the BOJ losses, right? Not the capitalization.
Past losses.
Past losses.
Accumulated past
losses.
What was done in the last fiscal year? What was provided for in this fiscal year?
No, this fiscal year.
It's a bit of both. So that last fiscal year, the $25 billion covered most of what was in the accumulated losses. There's still some left that had been carried forward. There was a large profit last year. So we're going through the process to just make sure as we work those numbers that the amount that there's a further amount to come in this year. There's to be sure that we take care of the amounts that from an accounting, this is all accounting really, that cover the past due losses to make sure it's zero. And then the additional amount would be the 22.6 billion on top of that to make sure that's the correct number. So this is in the bill here based on the 5% number, but you have to be sure that the amount that's put in covers the remaining past due losses. And the basic issue there, if I may share with the committee, is addressing the principle of the bank not distributing to the government any profit that is based on unrealized gains. Principle being you have to have cash coming into the bank before the bank should emit cash out to the government. Even if it's a profit, it shouldn't pay it out because that would be a monetary if you like, sort of like printing money. So we're just working through some of that accounting to work with the financial secretary to just make sure there's an exact agreement on the figures. So this year there's a provision for 25 billion that is already started to flow, that will go to the remainder of the past due losses and will cover this 22.6. So and I believe there's a further amount put aside for the next year, just in case these aren't exactly the right sums, so that the bank's capitalization is reassured once Parliament makes a decision.
This will be done by reference to your audited financial statement?
Yes.
Yeah.
Yes.
And this concept of monetary liabilities, is it a defined term in the bank?
We're defining it here.
We're defining it here.
Yeah, I don't.
Definitions. We had kind of discussed it. That it does not include the consolidated fund, for example. You remember? Yeah.
Page 2 on the bill.
Okay, and then section C, basically the difference between the paid up and authorized capital shall be paid by the government by the issue to the bank of marketable securities as such times as the board with the approval of the minister may require. This is separate from the dynamic. Governor?
Sorry, Chair, please.
Subsection C of 11.
This is a kind of call option that's given to the bank.
This will change based on the previous discussion, because what exists in the law had an authorized capital, a paid up capital.
This goes away if we take it out.
And then a mechanism to then increase it. And so this is trying to adapt that to what we had now, but we would review that based on the previous decision of the committee or suggestion.
Okay. Well, that would take us to clause 12 on the statutory capital, and that the statutory capital of the bank shall comprise the paid-up capital of the bank plus the sums standing to the credit of the General Reserve Fund established under 9. And you want to just, for the members, elucidate on the impact of statutory capital and why we need to put this provision in?
Chair, if I could just introduce Deputy Governor George Roper, who wasn't with us before, who is responsible for finance and administration in the bank, newly minted Deputy Governor, and he will take us through this section. Supported by Mr. Ian Williams, the Financial Controller, who is behind him. George?
Thank you, Governor. Chairman and committee members, what the definition of statutory capital does is allows for measurement of whether or not the capital of the bank, which will be its paid up capital, plus this general reserve, which is, if you put it in the commercial terms, is very much like retained earnings for a commercial enterprise. So it's the fund where profits for the year will be credited and any losses for the year will be charged. And so it is the capital of the bank.
Right. There's an analog in your Banking Services Act on how banks, profits go to a reserve fund and how distributions can emanate from those funds. And I guess it was probably redundant to ask you to do that, because the application of it is sort of outlined in clause 13, and this is where the dynamic capitalization exists. The existing bill basically says, or the existing provisions in the Act say that the General Reserve Fund, when it is 5 times the bank's authorized capital, net profits shall be paid to the consolidated fund. So there's no reference to monetary liabilities. And in clause 13 of the bill, we're removing what exists, and if I may just read it, subsection 2, where at the end of any financial year, the audited financial statements of the bank, as at the end of that financial year, disclose that the statutory capital, as Deputy Governor Ropo explained, of the bank is below 3% of the monetary liabilities of the bank, the government shall, within 4 months of the start of the fiscal year, immediately following, issue marketable securities to the bank of an amount that is at least equivalent to the amount by which the statutory capital would have fallen short of 3% of monetary liabilities, which shall be a charge on the consolidated fund. So, considering 3% of monetary liabilities to be the minimum capital that a central bank should have at any time. And it is, as we have discussed a few times earlier this afternoon, it is ultimately a call on the consolidated fund if it falls below. Reason being that without sufficient capital, the bank's ability to conduct open market operations, which are essential to the conduct of monetary policy, would be compromised. So from where we are now, the bank would have to sustain losses that would whittle it down from 5% of monetary liabilities to 3 and then to below 3 for that to come into effect. Just the delta between 5 and 3 is about, in dollar terms. Well, if 5 is 22.6, then about 10 billion. Huh? Right. And that's unlikely to happen in any 1 year.
This trigger.
I would say, Chair, it is the scale, the swings that can occur based on the size of the reserves and exchange rate movements and so on, and other items. You can have large losses.
But this is realized losses.
No, this is just losses. Yeah, not realized.
Losses, but the profit has to be realized.
Exactly, for distribution purposes. So we've separated the calculation of profit, so we stay with accounting standards, which means that what we're calling unrealized, in many ways, in an accounting sense, are realized profits. The concept of realized we're using relates to whether you've received any cash in. I mean, it's the same idea, but accounting standards for a bank like ours that trades, the assets that we're dealing with, those profits are typically would count as being properly earned. That's why they're in profits. But I think the issue here is that you're going to be earning generally profits, and you're going to be accumulating based on the dividend distribution rule here, so that you're going to be moving upwards of 5% normally, capping out at 8%. So that's the zone that you'd be then suffering losses from. So when you factor that in, you're not going to get, you might get a year with a 10 billion loss. It's not likely, but it can, and it's not common, but it can happen. Indeed, as we go forward and have more reserves and the economy grows, the size of these changes could increase, but then so would the percent of monetary liabilities. So that 10 billion will grow as well. So we think it would not prompt, this scheme should not prompt a recapitalization, right after we start, unless we have some misfortunes.
It's like a revaluation of the dollar reduces the value of the reserves in J dollar terms, and your accounting is done in J dollars, I assume, right? Yeah.
Of course.
Sorry.
The only currency that matters, man.
Yeah, right.
Well,
yes.
how can you ask a central bank
you guys
governor?
I just wondered if there was some inherent, if the earth
the whole purpose of this bill. The whole purpose of this bill is that the only thing that matters is the J dollar.
Chairman has to remember, what other currency might we be using?
Yes,
Chairman.
Wait, the question hasn't been asked yet. Sorry. No, so I'm just saying, so you may have losses, accounting losses from a revaluation of the currency based on the value of your reserves that could trigger a recapitalization requirement, which could shortly after year end be, especially in a exchange rate regime which is very market determined, moves fairly rapidly and in unpredictable ways, you could eliminate that loss quite soon after the financial year end and even move into profit. But the 3% trigger would have been passed, and and the obligation to recapitalize would have crystallized, because it's just based on, as you said, unrealized, counting profits, which take into account anything you mark to market. Yeah.
If I could say, operating on a sort of, for good order, operating on an annual basis, audited accounts. So there's some order. It allows the government to plan, because you actually, the audited accounts come by February or March, but the board and the ministry would know what they're going to be by the end of December, typically, in terms of these big items that could impact profits, so that you can properly deal with it during a coming budget. But I thought you were going to go on to say that then when you come to that next period, if those profits have been earned, then you'll have a distribution based on the formula that will then return, not all, but return 25% until you move back up towards the 8% of...
You only have the distribution if you've realized them in cash.
That's right, yes.
Yeah, so you'd have to sell the reserves to realize them. Yeah, okay.
Yeah.
Minister, you need to digest this one.
but also, if I could say, when you don't distribute, then the capital rises. So you'll end up with a bank that the issue that you were starting to comment on, which is where, okay, I'm at 5%, if I have a loss, I could go down below 3 and then have to be recapitalized. That's what, by having higher capital, makes it less likely. So that the idea of all of this is that the capital of the bank becomes a sort of an internal thing that the bank has to pay attention to and the public can see. And it ought to, absent sort of, unanticipated things or large structural changes, it ought to be self-sustaining and indeed should deliver on a general basis over time a dividend stream to the government, which in a way is close to like the seigniorage or, having a central bank generates generally over time profits, not losses.
What are the sources of your realized income for the most part? Interest differential on securities that you hold versus liabilities that you have? That's one. What are the main sources of income for the central bank?
That's it, yeah. Because, you have to add in the foreign reserves portfolio, so there's interest income, there's interest expense. For example, I've lived all my life with the idea that the central bank has a negative carry, meaning you lose money on holding reserves, because you have the money in the Federal Reserve at 0.5% or hardly anything, and then you're paying Jamaican interest rates to the banks at 2%, 3%, 4%, 5%, 10%, negative, a loss there. That's interesting that in the last, few months, last year or so, the Fed is actually paying a higher rate than our policy rate. Now we have other costs as well, interest costs, so it's not quite as low, but the carry is very, very small right now.
Could you just explain, other than the interest rate differential, what about, don't you make income from your open market operations in the FX market? For example, if you buy or sell currency, does that not go to your P&L, gains or losses?
Yes, and that's exactly where you will definitely get realized gains or realized losses from actual trading activity, interventions basically, or not just interventions where we buy, for example, we buy on the surrender from the banking system, the public sector enterprise surrender, cambios and dealers, and then a percentage of their business, and then we sell that to cover government costs, public sector enterprises needs. So there's that activity that generates, pluses and minuses, but because, essentially. So what
about seigniorage income? Do you have that as well?
And yes, we do. And the way you would see that is in the, if you look at the assets and liabilities, you have assets that we earn interest on, that's the government securities. But the liabilities, we'd have amongst our liabilities notes and coins, where there's no interest cost on it. There's just the cost of actually buying those notes, printing them, processing them, all of those costs. And when you net that out, there's a profit, there should be a profit built into the bank's operations that, again, in a steady state where everything else is normal, that's essentially profit for the government.
So, with a responsible fiscal that is, pursuing a sustainable debt trajectory and stable environment, the central bank should make profit.
Yeah.
It should on an annual basis. Our experience over the last, whatever period you want to say, let's just say 25, 30 years or so, must be seen as highly unusual because of the instability and the fiscal dominance.
Lack of capital.
And lack of capital the central bank has had.
Chairman, I just wanted to clarify. 13.2 speaks to the issuing of the marketable securities within a defined period in the new fiscal year.
I had commented on that.
And in the event that this is not done, there's a consequence that the bank now would have to increase the capital based on Section 8.4, and I assume that's Section 8.4 of the Principal
You've gone
Act.
ahead to 3.
Yes, I've gone ahead to 3, but I'm trying to make the link. First of all, Governor, what are some of the factors that may have contributed to the not getting the issuance of the marketable securities in the first instance? And what are some of the, if there were any experiences in the past?
There's no other source of capital.
Chair, I would say first, I think when we get to 8.3 here, that it's part of the same point earlier about authorized versus paid up capital that's going to change, because when we remove that concept, I don't think there's scope for 3, for the bank to act. So
I think 3 goes. 3 goes.
It has to go, I believe.
Yeah.
So it leaves us with the same fundamental problem, though, that you're asking, I think, which is what happens if there's supposed to be capital put in by the government and the government doesn't do it. The bank cannot compel.
Well, there's...
I think there's
they break the law, right?
There's no...
there's no other source.
There's
no other source.
There's no other source, and there's no other action. So, and in a sense...
Stalemate.
It's
no.
Well, you could ask yourself, why is the bank not properly
That's where
capitalized
the opposition comes in.
I think the chairman's point about the...
We raise a fuss, that the law is not being complied with.
Yeah, I think the chair, your point about fiscal responsibility and how that framework works is where I would say to the member that the action or compelling the action to capitalize the bank would have to come through that framework of the fiscal performance. These are fundamentally choices of the same body we're in now. That it has to be left there. Somebody is ultimately responsible. So, but I think the reason for the scheme to be structured this way is to say, okay, let's not leave it to that under the current arrangement where it's capital, there's low capital, and when it runs out, that's it. This creates a dynamic capital, as the chairman pointed out, and it generates, the aim is to generate a buffer from our earnings that takes you up to 8%, to create a bit more space. Because often what happens when the government won't capitalize, I don't think it's that governments just say, I don't want to. It's typically because there are all of these urgent priorities, debt problems, issues elsewhere, so that when you prioritize it, the central bank is, you can do it later. And so the result is it keeps getting postponed, and so it doesn't get done. So I think this allows us to plan ahead. And if I could just add, Chairman, one of the elements that is new that comes from this is the concept of policy solvency, which is the idea that just as you stress test a bank, and we talk about stress tests to see if they have enough capital, what would happen if the Bank of Jamaica internally will be stress testing and talking about it, its own capital, looking at the policy framework, take the FPP, take the inflation target, and then consider, when you look at all of that, what is the evolution of the capital of the bank that we foresee? And if that evolution of the capital, because of losses that are built into the framework, would erode the capital, it's imperative that the bank is declaring it, that it's factored into the discussions, so that years ahead, hopefully, you're able to see what is needed and then can be planned for. And I think that when you put those together, you have a very workable framework for maintaining proper capital of the bank and for holding somebody accountable, that would be the bank, if their capital erodes and they never told anybody and never raised it and never spoke about it, And I think the issues being structured here, the powers and the obligations to be accountable and to disclose, you would have board members probably screaming very loudly to the Parliament here about the erosion of capital and the government not capitalizing them and so forth. Right now, we don't empower that. That's not the way we were structured to operate, and that's an important change.
Right now you're kind of muzzled.
We advise the minister,
we advise the government. You say it in silent corridors.
Yes.
I mean, one, non-public sector setting, failure to meet a financial obligation normally would attract a financial charge, interest. So if the capital is supposed to be put in within X months because there's a deficiency and it's not forthcoming, there's some charge on that over time, Of course, in this setting, whatever the reason is why the capital hasn't gone in the first place is just going to be made worse by the adding of interest to it. So I don't think that's, and I can't think of any other.
Yeah, I wouldn't change. The question on the 4 months, though, which you had raised in the comment, Governor, the audited financials are as at December year end, and they're usually available by March 31st.
Yes, before March 31st.
So 4 months.
We normally have them ready in 2 months, Minister.
So you're saying that the government would have 4 months prior knowledge before, under this proposal here, before having to put in the securities up?
You have until the end of April.
It would have.
No, we have 4 months after the financial year.
Yeah, based on the law, 4 months. In
year?
practice, 5 months.
4 months after the start of the fiscal year. So 4 months after April 1st. But by April 1st, we know the losses or the profits.
You know them in an exact way
Your
under the
year-end
auditor.
is a December year.
Is a December year-end, yes.
Is that set in the law? Or that's yes.
It is set in the law, and if you recognize that when you come to the budget issues, you always have an audited Bank of Jamaica set of accounts. So that those monetary matters and issues of capital would be able to be dealt with
simultaneously.
Yeah. And just to again, I just repeat, that is correct, Minister. It's in law within 4 months.
But question though, Governor, let me ask this question. I mean, the budget is being prepared, the budget is tabled, the budget is passed by March 31st, right? We don't get the BOJ results until March 27th.
Well,
budget has passed, Senate already, it's done.
Yes.
No provision in the budget has been made for the issuing of securities at Bank of Jamaica.
Right. Which is why you actually get the bank's audited accounts before you table the budget. That's what we actually do.
So in our regulations, we have to say the BOJ audited financial statements have to be ready within 60 days.
But is that really? This is also to give you sufficient time to properly authorize the securities that have to go into the budget.
Yeah.
But as a practical matter, you are going to be dealing with all the other budgetary issues, and these are typically large amounts for which a provision would have to, an allocation would have to be made in the budget. So why not deal with that as an item in the course of the fiscal year rather than trying to accommodate it in a rush in a tight budget season when you're not even sure if the audited numbers...
So what they have here is that you have to do it 4 months after the fiscal year. So 4 months after April, May, June, July. So by end of July, you have to do it. Yeah. That's enough time to, on the mechanic side, on the security side.
In the second quarter,
I was thinking more of the planning.
Yeah, so I think of the planning, Minister, if I could just say, the numbers we're talking about that are big.
Sorry, normally when you put your fiscal policy paper together and so forth, and your other budgetary documents, you indicate what you expect to, what your borrowings for the year are going to be, and your repayments, and this would be a part of it.
So I think that in your interim fiscal policy paper in September or so, around that time, you'll have most of the year. You won't have all, so you'll have an idea of what could happen. Of course, things can change. I mean, exchange rates or global economy, etc. So that once you hit the bank publishes a balance sheet every 2 weeks. I'm not sure if the members appreciate that. We generate a complete balance sheet. It's very unusual for a financial institution, and it's published every 2 weeks based on the law.
So we will know. We'll have an idea.
So you have those numbers. You don't have them audited, so there can be changes. So in terms of magnitudes, in terms of planning for the financial secretary and so on, you have those. And then it's about dotting the I and crossing the T's, which then comes with the audited statement, and which would be. As I said, we actually have been meeting our own internal objective of having it ready within 60 days, so that we could deliver into the budget process and table in Parliament when the minister stands up to speak.
But your published numbers don't include a capitalization calculation as part of them because there isn't this top-up regime in place now, right? But should it, as it were, indicate capital adequacy on an ongoing basis so that the Finance Ministry and the public know, what we're heading towards. Yeah.
It is going to. I mean, we have to have the discussions with the auditors and so on, but it'd be difficult I can't conceive of the notes of the financial statements not saying what is the percentage,
from the point of
what's
view
required, and so on.
So I think that should be required or prescribed in some way, that be included. But also, from the point of transparency, if the deadline is not achieved, there ought to be the bank ought to be required to notify the Parliament or something, because ultimately the Parliament is responsible for the fiscal affairs. So that I think I'd suggested something.
I'd have a problem with that.
Which deadline are you speaking of?
Sorry?
4 months. The 4 months deadline.
If you don't get your securities,
within 4 months.
The public may not know this, So I'm just saying that then the board or the bank should notify the minister and request that it be completed as quickly as possible within the current financial year, and send a copy of that notice to the Speaker to be laid in the House, so that there's some transparency around it. Yeah.
I'd have a problem with that. Can we take that on? You heard?
Yes, Chair. I think this is I'm trying to figure out where did we hear this proposal on and thought it was a good idea. And it must have been from Member.
No,
I'm going to try and find it. Did you make this proposal before, Member Goldman?
I made it in my.
Yeah, I think so, in
memo.
his comments. So I think, it's a good suggestion.
Yeah, I'm saying if the 4-month deadline isn't met, the board should have to notify the minister that it hasn't been met and call upon it to be met as quickly as possible, and in any event within the fiscal year. And a copy of that notice should be sent to the Speaker to be tabled in the House, so that it is there's some transparency around this recapitalization issue, which ought to have happened and hasn't happened.
Yeah. All right. Subsection 4 of 13 deals with. We had 3 definitely goes as we discussed earlier.
Sorry, though, you're cool with the 4 months after the fiscal year?
Yeah, the 4 months can work.
Planning and everything.
Yes, in terms of issuing the securities.
Yeah.
Yes.
All right.
That can work.
All right.
Yeah. The subsection 4, the opposite now. Whereas at the end of any financial year, the audited financial statements of the bank disclose that the statutory capital is above 8% of the monetary liabilities, an amount equivalent to 100% of the distributable earnings for such financial year shall be paid into the consolidated fund within 4 months of the start of the fiscal year immediately following. Whereas at the end of any financial year, the audited financial statements of the bank disclose that the statutory capital is equal to or above 3% of the monetary liabilities and less than or equal to 8% of such monetary liabilities, an amount equivalent to 25% of the distributable earnings for such financial year shall be paid into the consolidated fund within 4 months of the start of the fiscal year immediately following. From the bill. Yeah. And then subsection C of it, whereas at the end of any financial year, the audited financial statements of the bank disclose that the statutory capital is below 3% of the monetary liabilities, no payment shall be made by the bank into the consolidated fund.
Given that you're starting at 5, I don't think you can be distributing 25% of profits when you've fallen below 5 and you're above 3.
When you're in the 3 to 8, you give 25% a year.
But we're starting at 5.
Yes.
So
next year, if there's a profit,
supposing it's
if you're at 5, you're going to go up to 5 point.
But this is not conditional on having made a profit. This is saying that if it's between 3 and 8.
No, it says of distributable earnings. So if it's a loss, there's no distributable earnings.
But there might be past profits.
When we look at the 5 and the distributable earnings provision, right? The
Section
language
5
is
defines it.
Yeah, it means profits, so not losses.
Look at subsection 5 of 13.
It doesn't mean in the current. It doesn't mean in the accounting period that's just complete. It can include past profits, right? Accumulated profits that are in the reserves.
So, shall we look at 5 now, Minister? Because I think that there's stuff
let's
to
look at
unpack
5.
there.
Let's look at 5.
Yeah, because 5...
Distributable earnings means the profits of the bank. Yeah. So the profits there, can mean not just this year.
That's the accounting profits of the year.
What we mean is, what's intended is this year's profit.
Yes.
Yeah, that's what's intended. We might need to fix that.
Yes, okay. So you
but
take.
Why
can I generally explain it, maybe, if I could?
You can normally distribute distributions out of reserves.
Yes,
right?
but think about it. In this instance, we are happy being between 3 and 8. We're just saying if you're between 3 and 8, you should not keep all of the new profits that you make. Once you get above 8, then you give us all of the profit. You distribute in 3 and 8.
My only thing is, you say between 3 and 8, but you're capitalizing initially at 5. So if you're between 3 and 5, you've actually lost capital based on where you started.
Yeah, but if you
so why are you distributing?
No, but if you go to the new definition of distributable earnings,
yes.
When we define distributable earnings to mean this year's profit, then that case wouldn't arise because you drop below 5 because of a loss. So distributable earnings, if it means profit in the new definition.
But in what circumstances would you be making a distribution when your capital has fallen below 5.
So I think, Chairman, the
it would have to. The circumstance
out.
here. The circumstance would be you drop below 5 this year because of a loss. Next year, so you drop to 4. Next year, you make enough profits to go up to 4.5, and you would take 25% of those profits for that year.
I just think,
as long as they're distributable, profit and earnings are meant to be different here.
Once your capital is less than it started out at, we shouldn't be distributing, because there's a reason why you're starting with 5, right? So to my mind, it seems a little anomalous that you could have actually reached a point where you have less capital than you started with and you're distributing. Yeah, I don't think you should be distributing where your capital has fallen below your starting point.
But I suggest, Chair, I think the benchmarks we want to focus on, I think for that purpose, is 3 and 8. That's what we're really establishing. We're saying 3 is what you don't want to be below.
With all due respect, the taxpayer of the country are putting in $22 billion that could have been spent to fix the water system on capitalizing the BOJ to achieve 5% of monetary liabilities. If we are below that yardstick, they should have to recoup that in their balance sheet before any distribution can be made. That's my own view, because that is the reason why in a tight fiscal environment, which we still are in, that we're going for 5 is because that's considered to be prudent. So if it's prudent, then let us not be taking money back out of the bank when our capital has fallen below that, because losses will have been made. That's the only way the capital can go below, is because there have been losses.
So I think, Chair.
So the scheme that you're saying would be below 3 you recapitalize, between 3 and 5 there are no flows either way, between 5 and 8 you distribute a percentage of your earnings, and above 8 you distribute all of your earnings. Does that do an injustice?
I think, Minister, I do think this is like a ministry, public purse versus central bank. Central bank is never going to object to accumulating and not distributing. But I think you have to, the very point you make, you put in the obligation, your guts, sorry.
If we started at 3, if we started instead of at 22, we started at 3%, so that's what, 12 or whatever it is, yeah? Yeah.
That this sounds like a technical issue that requires some consideration, and present us a position so we can see which of the 2 positions better serves the objective. But let them
we can do that. I know we're coming up to 5. Yeah. Maybe it just makes sense to finish the section, the part. Does it?
Yes.
Even though I'm happy to go.
So, Chair, I think this number 5, we have profit and loss, which is calculated in a proper accounting way. So that will be normal. When we're calculating how much to actually pay, we're going to use a term distributable earnings. It's not profit. It is this number profits for the year, but we're not going to allow the bank to distribute to the government any of those profits that arise from activities that didn't involve realization in the concept where we actually do a transaction and get paid for it, so that cash comes into the bank from the public. So we exclude unrealized gains, and this is A and B are foreign exchange gains and any other assets. You'd have to think of things like basically bonds, securities that have a value that changes. Typically, that's what we're talking about. But then we are saying that now, but what if during that same year you actually do a transaction that realizes the gains that were recorded in a prior year, okay, where you had profits, but you didn't distribute it because it was unrealized.
The following year.
So in this year now, it's being realized, it will be distributable. And that's the reasoning of 4. Profits, less unrealized gains in the year of those profits, plus realized gains from profits recorded in a prior year.
Yeah, understood.
Okay.
Understood.
But this provision needs to be reworded.
Yes.
We are agreed on
Yes,
that.
yes. To
Because
define
all of this
profits.
is excluded. All
Huh?
of this is excluded, but it sounds like we're adding things back.
No,
No. Can I just clarify if I could? Because yes, it means profits, excluding A and B, and what's meant where it says to which is added, that's not meant to be a part of B. It's meant to be to which is then added the two items below.
It could be redrafted to make it clearer. There's a plus, there's an exclusion and an inclusion.
Yeah.
Excluding unrealized gains and of all types.
So what is added is to profits plus current year's realized earnings.
Correct.
Yeah, what is added?
Correct.
Plus what?
Realized gains this year that were in the profits of a previous year, just to be clear.
In a private sector sense, it's very straightforward. I mean, it's whatever was unrealized in the past that you realize in the current year.
Right.
And when we say current year, are we talking about
current year meaning the year just ended?
The year of the financial statement.
The year just ended.
That's not the current
That's
year.
not the current year.
The year of the financial statement.
It should be the reference year.
The reference year.
You don't use current year.
Yeah. Correct.
Yeah, the reference year, which is the year that you've just got your audited.
Right. So we need to redraft
I think
it to
we've
make
defined
it
it
tighter.
somewhere in the text as well, financial year and so on.
Yes, financial year is defined.
Yeah.
We need to make it tighter, including the definition of profits. That's too loose. You're really talking about the accounting net profit for the reference year.
We want to use the term which is already in the law, where we say profits, then the accounting standards, whatever those require, that's the profits. So we're trying to make sure the statute is not setting up any different concept of profit from whatever the accounting standards,
But profit is usually determined with respect to a period of time.
Yeah, yes, absolutely. Your point about making sure we know which year it is, I totally accept. Yeah.
Okay.
Yeah. And then there's a slight wrinkle to this. If this is broadly acceptable with some rewording, there's a little wrinkle that we've spotted. The language that says in the last section there about the unrealized gains of prior years that are realized during the financial year, there will be the situation where there may be gains that were realized during a previous year, but in a year in which there were no profits, and so there will be no distribution. We want to be sure that those gains can still be brought out and distributed, so that the language that would be amended at the end there would say, or in any prior financial year, but not previously distributed. So that you don't have a situation where there's a year in which you made the gain on this asset, it was a book gain, not distributed. Next year, you realize the gain, but because you have losses that year, not distributed. The next year, you have gains, and you can now distribute realized gains, but the wording we have here, without the amendment I just put, would not allow that year's realized gains to be distributed.
Just by way of example, in year one, you make a loss of 10. That included realized gains of 3. All right? But there was a loss of 10. In year 2, you make a profit of, let's say you make a profit of 8. So you've actually, the prior year's losses have not been fully recouped, but there's a current year profit. That, if the word profit for the purpose of distributed earnings only means the current year, then the only limitation on distribution would be whether or not you're within the 3 and the 8. Is that correct? Yeah. Now that needs to be thought through, because I don't see how you can be distributing current year's profits with unrecouped past year losses. That's not normally allowed, certainly for financial institutions. So that's something we need to consider. Furthermore, if you're adding to the current year's profit past realized gains that have not yet been distributed, you could have a situation where what you can distribute is more than the current year's profit, right? By definition.
Remember, you're only still taking a percentage of it until you get to 8, right?
Right. True.
But the reason for that is, remember, that now you've got a central bank that has not only made a profit of X, but also through transactions, it has actually realized or brought cash in on a trade that doesn't record a profit this year because the price movement was last year. So it made the gain in last year, but it didn't distribute it. Because it was not realized. You've now realized it. The thinking here is that, well, because that has now come in, those profits that previously weren't distributed for that reason should be made available to the public purse. Subject to the distribution percentages now, which is a different filter. So the idea is that whatever profits we make as a central bank, once they're realized, they ought to be distributed. If you have losses, you shouldn't distribute anything, and that over time the government would receive through a dividend those funds, so that the public purse, the bank is not sort of inflated in what its capital is, basically. That's the thinking behind it.
And to the extent that we take a more cautious approach on the 3 to 5, which that's something I remember discussing, then it lessens the likelihood that you actually get below the 3. Whereas distributing between 3 and 5 accelerates 3 coming.
Absolutely. I mean, if you follow the suggestion made earlier on that, it will just reduce the risk of
it would reduce the risk of falling below. So the instances of falling below 3
will be delayed. But on the other hand, it means that the recovery to the fiscal, in a sense, the burden on the fiscal is therefore higher for longer. And and the question is really at what striking that balance, and you can set that at the 5 or the 3. It's perfectly fine.
Where is the accounting for realized and unrealized gains? Because your account based on IFRS or whatever standard you use, based on the principles, generally accepted accounting principles, which determine whether what your profit is. Some of that, because it's an accrual accounting and so on, it's where do you sort of, if you're trying to say what should be distributed, how do you know, where do you track back?
You'll be running those accounts and you'll be tracking them.
And you see it in your cash flows. I mean, it's similar to the provision, it's similar to what exists for the commercial banks by way of regulation, that you can't, if they have securities on which they have had fair market gains, they can't, to the best of my knowledge, you can't distribute out of that. It has to be realized.
And I think it's not a complex balance sheet, sort of from that point of view. So it is foreign exchange, it is the securities, the government securities portfolio, more or less. There may be a few small things, but that's what it will be. And so you're able to track those using the accounting standard for whatever the principle is, first in, first out, last in, whatever. And we'll be tracking what's realized from the perspective not of accounting now for the distributable earnings issue. It's about was any money, it's a monetary policy concept. Did the money come in? And if it did not come in, then we should not distribute to the government, because that would create a monetary policy emission. So it's essentially aiming at that, but using the accounting environment as the main standard. That's the profit and loss that you just mentioned. And then instead of changing the definitions of profit and loss, which would create confusion, we now just develop a specific central bank distribution rule that's only for this purpose. And it's about how much should the government have.
And who would sign off on that? Who would sign off on that? There are these past realized gains that were not distributed, and what they are.
I think that's actually a good question as to how should that be certified in some way by somebody.
Yeah, because it's a bit elusive if it's not in the audited financials. Yeah. It's something that you're extracting from something that is not in the financials.
Yeah.
And so it's...
Well, and I think one approach, and I think you were touching on it earlier in a slightly different context, is for it to be in the audited notes or something, so we know what is distributable.
I mean, it could be in the regulations that audited financial statement shall include a statement of.
Yes, I mean, perhaps if the members would like, we could consult with the auditors just to be sure, because it may be that this sort of thing is, once this is written this way, it's covered.
Can I also make a suggestion that rather than move from the drafting to try and work out the concept, I think that the concept of what your distribution rule is should be set out as an accountant would set it out, and then the drafter can use those as drafting instructions to put it to text. I think it's very important that the accounting meaning and the accounting approach, because it's all going to be driven by that, should be clear. And so we can then draft from that once we agree and understand what the overall distribution rule is.
I think in the preparation of this, we have been consulting with our auditors informally, and I think we can make that a bit more formal in the process, just to make sure that this does what we...
I would like to see a memorandum from the auditors, or from you, which the auditors would agree with, setting out what the distribution policy or rule, the proposed distribution regime is from an accounting perspective, that we can then understand and put into the law.
And we're agreeing that the regulation would stipulate that the audited financial statements would need to have a statement that verifies unrealized and realized and has a schedule, puts the years 2018, 19, 20, unrealized what it was, realized what it was, and keep updating that schedule.
Yeah, I mean, when we get...
Could I maybe suggest that you would require that the distributable earnings accounts are disclosed or explained? That the distributable earnings, the accounts that generate this definition, are disclosed in the notes of the financial statement or something like that.
Yes.
But in order to do that, the concept of what are distributable earnings needs to be very clear and coherent. And it should be driven by, I think, by an accounting explanation of what goes in and what comes out, what's allowed, what isn't.
Technical definition and how an accountant would express it. Like in a way you'd write IFRS, essentially, how you'd express it.
But if I may just say, and I think that's a good suggestion, but just to be clear that the accountants need the guidance from us as to what do we want. So just to be clear, so it's not them writing what it is and then we follow it.
Right.
We're constructing this for the purpose I've indicated, and essentially this is what
I accept that. In other words, because of the peculiarities of a central bank, where the distribution of unrealized gains affects money supply, right? It needs to be in sync with those imperatives. Yeah.
And the feature of what we're doing here is to be very careful to try to leave whatever the accounting standards are that should apply to the bank, leave them understood so that the bank will always be meeting those requirements. And that what's different is then this distribution element, which is a choice of this Parliament. So what we can do is create a memorandum of the accounting, discuss it with the auditors,
regime.
Also discuss the disclosure issues with the auditors, but again, no objection to the rules or regulations, including the right language that would cause the auditors to include in the notes the disclosures on distributable earnings. I would like to just consult a bit on the policy solvency point that I touched on earlier, because in a way that's also grappling with the same question of what's your expected level of capital. Yeah.
Okay, I just propose to finish clause 14.
Mr. Chairman, just a quick question. Governor, just a quick question. For the securities that you will have on your balance sheet, would the bank still be subject to the rules in terms of having to say whether they're held for trading, held to maturity, or all of that? So that's going to impact where you recognize your unrealized gains or losses, right? Okay.
Just confirm that the bank operates under the generally accepted accounting standards, which are promulgated by ICAJ, and those are the IFRS standards. And so we have to follow all of those requirements.
Will you be making a decision whether particular securities gains or losses unrealized go to the P&L as opposed to go to some equity account? Will you be making a decision how you allocate your securities into different buckets?
Yes, I think that's the question, if I understood. That's the question, do we have to assign designators, held for sale, or the other definitions? I can't keep up with them, they've been changing. The answer is yes, and then we have to do it on the basis of like any other bank would. But I don't know if Mr. Roper or Mr. Williams have any comment on that to elucidate more fully, other than that, yes, we have to follow it.
Would there be any different buckets for the central bank? Why wouldn't all the securities be treated in the same way?
There wouldn't be. There's no special treatment for the central bank. The reasoning would be based on. There'd have to be the some reason to differ. You mean where we'd have some securities in a held for sale account and some securities in an investment account? Is that the kind of question you're asking?
Held for sale
or
profits from which go to P&L,
right,
as opposed to balance sheet.
There wouldn't be, as far as I can think, any reason we have to treat all securities in the same class.
Back in the days of instability, you can understand why it would have probably been dealt with one way.
Yeah. I think the bank's balance sheet, I can say, and I just need to testify to that to this group, the bank's balance sheet has never been cause to be concerned about its integrity, whether it's accurate and so forth, and the standards that it moves to. But I think I can go further, because I think that the bank has always tried to be, at the front of those standards when it comes to the integrity of its balance sheet. Part of it is that we have to publish it every 2 weeks as well, and doing that required a particular transformation for good reason, so that you can track what's going on with these accounts.
Now that there's going to be a call on the budget based on profit, the way in which these things are booked in your accounts makes a difference to what your profit is. So, that's why I'm asking the question: what is the categorization that is applied to the securities that you will be holding, the ones that are put in as equity, for example? Yeah.
What is the actual categorization we use now? Can you?
If I might speak, thank you, Governor. Yes, so as the Governor said, the accounts are prepared in accordance with local generally accepted accounting principles, which are IFRS. And so there are some securities which are recorded at fair value, with the fair value adjustments going through the profit and loss, and there are others where the fair value adjustments go through what the accountants call other comprehensive income, therefore not through the profit and loss. Or Mr. Williams will tell you that our statements are compliant, because we do have the scrutiny of the auditors, and there are other international bodies that review our accounts. Our accounts are heavily scrutinized.
Who makes a decision whether it's treated in one way or another when you acquire particular securities? Who is it that makes that decision?
The IFRS have rules, and so you have to look at the particular business model, and in relation even to our portfolio of assets, as you know, we hold the nation's reserves. They're held in different tranches. So some investments are held for working capital, some for liquidity purposes, and where we have satisfied ourselves that those tranches are fully at the levels where we'd want them, there are some that are held for investment purposes.
The decision making on those categorizations occur through the structure of an investment, investment policy that is approved through an investment committee that ultimately reaches the board to approve. And then the audit and risk committee reviews those standards, that kind of structure for the decisions of these things. And then the accounting treatment then has to flow based on whatever it is you do, including, I believe, the accountants and auditors have to check. You can't just call something tradable and then you can't find a price to assign to it. There have to be markets. It's the same standards as the rest of the market.
You have all that IFRS 9 issue and all of
that?
Yeah,
all of that, yeah. We have to comply with all of those standards. If we don't, then our accounts would be qualified, and then you would see the qualification. And I should just mention that many central banks in the world operate on the basis of qualifications because their parliaments or their structure, their laws, create differences. Jamaica is managing to, and we think this is best practice, to structure even this discussion here so that we do not interfere with anything that could change accounting standards as they evolve, and then make anything that's a statutory reason a sort of a separate thing. Here, in this case, the distribution rule, so that when you look at the bank's accounts, you can be confident that it's applying those rules, and if it weren't, then there would be a qualification. We also have management letters and so forth, and we're very pleased that the number of comments and so on are very small. The bank acts with a lot of alacrity on this side of things for obvious reasons, so that there would be impacts on confidence where there are concerns. We're not perfect, so there will always be something, but those are kept to a very small minimum. I believe as we move into this regime, there will be, and we would welcome it, much more scrutiny, of the bank's balance sheet, the bank's audited statements, and so forth, so that people can be informed about these things. But I think the committee can be reassured about the accounting standards and how we are audited, so that you can be satisfied that what's presented is in fact in compliance.
The basic distribution rules should be that which is normal for corporate entities, subject to particular modifications that are appropriate because of your role as a central bank. That's the kind of...
It's possible to do that. I mean, in our case, because we're different, in the sense that, we're just trying to generate a buffer to deal with that question of the fiscal suddenly having to provide capital, and to generate there's a shift in the kind of responsibility for profits. The regime that we currently have, which was designed way back in the 50s and implemented in the 60s, distributes all the profits and any loss. So it followed a model that said, well, the central bankers, we don't have to care about whether it's a profit or loss, we have to care about monetary policy. What this new capital system is putting in place is saying that the institution, in this case the board, has to have some fiduciary responsibility for this capital level and answer for changes. Now, we know that it's still monetary policy that's the main thing that will shift it. And we don't want the bank to be running a monetary policy that is going to be aimed at having more profit, okay? That would be a disaster. Central banks can do it, but you want them to have a monetary policy that's appropriate for the inflation target, etc. But there's an implication to profit and loss. And so this accounting treatment and this capital arrangement then obliges the bank, the board, and the institution to pay attention to how will that profit and loss evolve. And the capital buffer gives time to make sure that you can telegraph to, it's ultimately a public government question, to recapitalize or not. And if you have to recapitalize the bank a lot, then why? If there's not been a shock, then the answer will be that there's something inconsistent in the policy framework of fiscal and monetary policy that is generating this loss. It's not consistent. And so it will be another thing that lets people, the committees here, ask tough questions and be reassured or not whether the loss that's coming up.
There could be some contingency, there could be some fraud. I mean, there are lots of things that can generate
precisely.
a loss.
There can be things like that, and then you're into a different level of scrutiny, public accounts committee and so on, and that's just for public sector generally. There's nothing special about the bank there, those losses. And then the third thing I think in line with that could be just shocks. I mean, things happen, and part of what happens is the central bank's balance sheet absorbs the shock. And that's why you have, for example, a reserve. Let's assume one shock that Jamaicans aren't thinking too much about, I think, because they're thinking of the opposite, is an appreciating currency, a secular appreciation where you're holding lots of reserves, but the exchange rate keeps getting stronger and stronger and stronger. The central bank will then make the losses you mentioned, and then the question is, well, what do you do about that? You can go ahead and recapitalize if that's preferred, or maybe it's telling you something that in the mix of policies, either there's too strong fiscal, too strong monetary, inflation target might need to change. So it can prompt, it's like a canary in the coal mine. When you see the capital change on a sustained basis, there has to be an explanation, and that explanation, absent shocks or fraud or other things that you mentioned, would typically be in the mix of monetary and fiscal policies, the macro framework. There's something in it that's generating this, and it needs to be attended to. So I think this is one of the reasons for having a capital buffer. So it's not like a private company in that sense. It's there for that purpose. Thank you, Chair.
I think this has been a worthwhile discussion. The fact that we are moving to a regime of dynamic capitalization and where the taxpayer is ultimately on the hook means that these terms have to be precisely defined and have to be properly certified and have to be transparently displayed in the audited financials. So we want to make sure that the regulations specify the calculations that must appear in the financial accounts, as Member Golden has been suggesting, that we get the conceptual definition and distribution regime expressed in precise accounting language so that we can ensure that the legal language reflects, when the technical interpretation of the legal language occurs, we don't have a disconnect.
Mr. Chairman, in whatever memo or explanatory notes that come back, I'd love to request the different scenarios and have some figures attached to them so that we can see kind of the outcome or implications of some of these different scenarios, some what ifs, yes.
Sure. Okay, I just crave your indulgence for just section 14, clause 14. It just brings us to the end of this part. And clause 14 refers to section 23 of the bill that allows the central bank to grant loans to institutions and then has a proviso provided. What it says now is that such loan granted on any such security, this is what the Act says, as is mentioned in the above paragraphs, shall not exceed 75% of the current market value of that security. So it provides the collateral terms in a very fixed way. Subsection 14 of the bill. Clause 14 of the bill, on page 12. So what this says is, provided that the maximum loan or advance granted on any such security shall be based on the bank's determination of the risk of such security losing its value during the life of the loan. In the Act, it specifies that the amount cannot exceed 75%, which is too rigid for the regime that we're entering into. The bank needs to be able to assess the risk of loss on the security. It could be that they could advance 90% against the security, right, depending on the nature of it.
Chairman, this is one of the clauses that Member Bunting alluded to, and maybe it would be a prudent thing to not pursue 14 now, notwithstanding the time there, and maybe because of the time, and allow him to get a chance. We assume he will be here next meeting. So since he has raised this along the way, let's come back to 14.
Yeah. And when we talk about value here, losing its value, we're talking about its fair market value. So maybe we should make that clear, because value can mean different things in different contexts. We're saying, that it could be some credit event, or it could be some other thing that would impact. Fair market. It's realizable value in the market, basically.
Yes, exactly.
Yeah.
Senator Brown, I'm happy not to conclude anything and give Member Bunting a chance to opine, but this is moving in his direction. It's just saying that the Act today says it's too rigid. It says you can only lend a maximum of 75, and this is saying no, forget the maximum. Just say, the bank's assessment of the fair market of diminution in the fair market value during the life of the loan. So it permits, what it would permit is lending 100%, or 99% or 90%, whereas today that's not permitted.
Close it today. Let's come back. It's a short one, but give him an opportunity to comment. And we'll get to 15 after.
I have no problem with that.
Yeah.
No problem.
And you said J, were you going to the removal of deleting paragraph J?
Yes.
Is the next item,
and
which is not related to Member Bunting's point. That J is a clause that provides to the bank the power to. This is eliminating the power for the bank to be able to invest in other assets. Which one? Yeah. It says, J says, with the approval of the minister, the bank can grant loans and advances for fixed periods to, or subscribe to, or hold and sell the shares of any corporation, which, with the approval or authority of the government, is established for the purpose of promoting the development, etc. So this is eliminating the ability of the bank to own shares in anything at all.
Understood. But I will, Senator Brown, no problem in accepting your suggestion.
Sorry.
Chair, we need to also note the comments made by the JCC in relation to this clause in the matrix.
Mm-hmm.
When we JCCUL, when you're considering the entire clause, yes, that we'll have to delete reference to paragraph J in section 24 of the Act, 24(1)(c) of the Act. A consequential amendment.
Where?
Page
Yeah, I saw it.
I can share that the 24.1c. This is in the Principal Act. 24.1c is the part that prohibits the lending of money by the bank or making advances other than the terms at 23J, 23F, J, and M. So you have
we'd
to
have
amend,
to eliminate J from that.
Yes.
Yeah.
You have to take that out.
Yeah.
So it's a consequential amendment that this should be included.
Yeah, I mean, that makes sense. Okay. Can we move to any other business? No, so Member Golding, in the Principal Act, in another section, it talks about not being able to make any loans except as provided by subsections J, K, and we are deleting J. So if we're deleting J, they were just saying that there's a consequential amendment, a minor one.
Other point you said at the Jamaica Chamber of
That
Commerce.
was it.
That's it. Oh.
That's it.
Oh.
Yeah. Yeah. So can we move to any other business? If there are no other business, date of the next meeting, I have the approval of the committee for next Wednesday at the same time, 2 o'clock. If so approved, so shall it be. And may I have a motion for adjournment of the meeting? Seconded. All in favor? Thank you all very much. Thank you.